And clerk will open the roll.
Mr. Chair, you have a quorum.
All right. Well, I think we're going to start with Senator Cosgrove.
Good morning, Mr. Chairman.
Good morning. I think you've got Senate Bill 49.
Yes, sir, Mr. Chairman. There is a line amendment to the bill, sir.
All right. Kristen or Charles?
You don't have it? All right, here. Unfortunately, it's not the PDF, so I don't have the line number on it. Thanks.
Hope your chief of police was able to hitch a ride with Ms. Parr today.
Well, Ms. Parr is here. The chief, I think, is stuck in traffic on 64 on the bridge coming over
It's not
into
weather,
Richmond. But he is on his way.
Do you want to wait for your chief?
No, sir. Mrs.
Okay.
Parr is very capable.
All right.
All right. Mr. Chairman.
I don't have the line amendment. Do we have some?
Mr. Chairman, this is one of the line amendments you and I talked about.
You want to report it, Charles?
Hey, Senator, how are you?
Mr. Chairman, on line 20, after such information, the amendment strikes in determining whether to make reasonable accommodations.
That's it?
That's it, Mr. Chairman.
That's it, Mr. Chairman.
All right.
Well, Mr. Chairman, Senate Bill 40.
Why don't you tell us about the bill
Sure.
and then what this does before we adopt the amendment?
Absolutely. Mr. Chairman, Senate Bill 49 will require any person who is currently on the, or in the future, on the sexual predator database to report to existing law enforcement authority in the event of a natural disaster or any time that a shelter is opened in one of those events. This is actually brought to me by our police department and the city of Chesapeake. It also has the support of a number of law enforcement agencies, Mr. Chairman. We know what happened during Katrina down in the stadium there. We've had other disasters where emergency shelters are having to be opened. And what all this bill does, it just says that if you're on the sexual offender list, you have to report to law enforcement there. Basically, in striking that amendment, basically takes out whether the law enforcement have, say, whether to make reasonable accommodations. Nobody's going to be turned away. All right. All this does is just say, look, they report to the law enforcement there. I'm on the list. Law enforcement knows they're there. And basically, I think it's important that we have that information available to law enforcement. You know, women and children are in these shelters, and I think it's probably a pretty bad idea to just have somebody that's on that sexual offender list in there in close proximity without law enforcement being aware. And that's the bulk of the bill, Mr. Chairman.
All right, and your line amendment takes out reasonable, determining whether to make reasonable accommodations.
Yes, sir.
And why do you make that amendment? Is that to remove the burden from the shelter staff?
It takes some burden away from the shelter staff. It also ensures that those people are not going to be turned away. Nobody wants to be turned away from emergency shelter. All we want to do is just make sure that the law enforcement is aware that that person may be there. So there's no sectioned off area of a shelter. It's simply information to law enforcement.
All right. Is there a motion to adopt the amendment? So moved. It's been moved and seconded that the amendment be adopted. All in favor signify by saying aye. All opposed. So let me just ask you, so this does, in addition to imposing an obligation on the sex offender who has to report his presence, in lines 20 and 21, I mean, it still imposes an additional obligation on shelter staff during the emergency. What are they supposed to do to use that information to ensure the safety of all persons in the shelter?
Well, Mr. Chairman, that would be up to the law enforcement agencies that are there. Law enforcement said
But this isn't just law enforcement. I mean, this is shelter staff, and I assume during an emergency, there may not be law enforcement there in the shelter.
Oh, Mr. Chairman, if I may defer to Commonwealth's Attorney Parr.
Sure.
Perhaps she can clarify this a little better than I can.
Yeah, that'd be fine.
And hopefully my police chief who asked for this will be here shortly.
Hey, Ms. Parr? What do you think of this fine bill?
Mr. Chair, Nancy Parr, Commonwealth's Attorney for the City of Chesapeake. And we support this bill. My office supports this bill, Mr. Chair. And I had stepped away because I was asking the state police if I could represent something that he had told me this morning, that shelters that are run, that are opened by the state police, and I don't know the details of how that happens, but shelters that are opened by the state police.
You may have a lifeline behind you.
I do, but that the state police in their shelters, when everybody who comes in, they are checking them through the computer network. The state police are already doing that in the shelters that they open. I'm not clear on the difference between shelters that the state police open and shelters that localities open. I don't know what that difference is, Mr. Chair. But I did ask the state police if I could represent to you that that's what they do.
All right, maybe, yeah. And Chief, good to have you here.
Good morning.
Yeah.
Good morning.
And I know that this is your initiative. My question to Senator Cosgrove was, you know, in lines 20 and 21 of this bill, I mean, number one, the bill requires a sex offender to tell shelter staff of his or her presence. Second, it also requires staff to use that information to ensure the safety of all persons residing in the emergency shelter. What are they supposed to do?
Well, for us, it has to do with those, particularly those who are on the registry, who as a condition of their release cannot be around children or people of the opposite sex because of their status as a condition of their probation or parole. For us, the way I envision it is that staff, particularly law enforcement who are responsible for security of these localities or these shelters, will then determine how best to manage someone who's in that particular case. Because herein is the dilemma. If I'm on the sex offender registry and as a condition of my probation and parole, I can't be around children or others, then by them coming to the shelter and law enforcement being aware of it, we then help them facilitate being in violation of their probation and parole. So it may require us to separate them out from everyone else that's at the shelter. But this is by in no means a tool that we want to use to deny anyone service.
So don't you achieve your purpose if they simply have to notify staff of their presence? I mean, in an emergency, isn't staff going to do what they can do to ensure the safety, given the circumstances? I mean, I worry a little bit that this bill, it says shall use or use this information to ensure the safety. What if they, I mean, it's just such a dire emergency. I mean, they don't have the resources to do anything. Don't you think that they're going to be doing what they can do to ensure the safety of people in the shelter?
But you can't do something against a potential hazard that's unknown, that can be known to you simply by someone coming to the law enforcement who's responsible for security and making their status known that I am on the sex offender registry.
Why can't they use that information to take steps to ensure
We can.
safety? Okay.
We can, but there should be notification because otherwise a police officer or deputy sheriff would not know that someone's on the registry.
But my point is, why is everything else in the bill? Why not just notify staff of their presence?
I can't speak to that. I did not draft that portion.
I'm curious, counsel, whether, the rest imposes burdens that may not be able to be met, that may impose some strict liability on the shelter or shelter staff, and whether an amendment stripping that down to essentially the bare essence would achieve the patron's objective. Let me ask counsel.
Mr. Chairman, I think you're right.
John, you
I could have
object?
said that. Mr. Chairman, you were very generous in talking to me about some of the issues with the bill prior to this coming forward. We thought it was important to bring it forward, just because we know, there have been weather incidents and so forth. This seems like a fairly common sense bill, but if it's such a shape that, go ahead, sir.
Well, let's do this. Let's hear from those who have concerns about the bill or
Sure.
wish to speak in support, and maybe council can work on something. I know Senator Spruill has the same bill, and at an appropriate time, we'll roll these together and do whatever we do to one to both of them.
Okay.
And so, Jeff, you want to speak in support?
Briefly.
Okay.
Thank you, Mr. Chair, committee members. This did come from the city of Chesapeake, and that's who I'm representing. And to your point, Mr. Chairman, the intent was not to put an undue new burden on shelter staff around the country. Around the state. That's certainly not the intent. So really the notification is the key piece of this. So city would consider it a friendly amendment, assuming the patron is okay to clarify that. Thank you.
All right, thank you.
Mr. Chairman, members of the committee, Bob Mathias from the city of Virginia Beach. We obviously have a lot of disasters. We had Hurricane Matthew last year, 2 years ago, where we had to shelter a bunch of people. And this sort of will be, I think, beneficial to both the folks who do have something hanging over their head, sexual abuse, things like that in the past, and also the people that run the staff. We'll have some fairly clear rules on how folks like that should be handled. The people that do have a sanction on them will know they'll have to report, and the folks and the staff that are running the show will be able to take appropriate measures to make sure that they don't get in trouble either inadvertently or otherwise. Thank you.
Thank you. Anybody else wish to speak in favor?
Mr. Chairman,
Yeah.
I'll just say my part, and I can leave it alone. The only difference between what the senator has and what I have is that as for the sex offender himself being separately, that I had wanted to put an amendment on it that when his family come in, that the family go with the sex offender, that not to have him to be in one location and his family go somewhere else. That my part of the bill was saying that wherever they put the sex offender, allow his family to go with him.
And I think we're stripping this down to a point where it gives shelter staff, or if I predict accurately, gives shelter staff more discretion about what to do, just so long as they have that information. All right, thank you. Those who'd like to speak in opposition?
Mr.
Welcome.
Chairman,
Good to
good
see you.
morning. Mary DeVoy. First, I'd like to thank Chief Wright for the First Amendment, but there are still problems with this proposal. The first is the mandate to report to a local law enforcement location within 5 days. An emergency shelter is a temporary situation, not a change in residence. A few years ago, I confirmed this very point with the state police. Any Virginia registered sex offender who visits someone or takes a vacation within the state is not required to re-register that temporary location. This is so Virginia's registry isn't bogged down in information that will be removed in a few days. Let's consider the reality of an emergency. There could be extreme flooding, downed trees, roads that are blocked or destroyed, and dangerous winds. This proposal mandates that RSO must venture out out of the shelter into the dangerous conditions, most likely on foot, to find the local police station, which may or may not be open, to advise them of what has already been declared to the shelter security. Let me remind everyone, last Wednesday, this bill was delayed because the chief was unable to make the trip due to some snow. If emergency shelters are open, the conditions are severe, possibly deadly. Notification to the shelter security should be sufficient. I ask that Section B be stricken. Last week, Chairman Obenshain opposed a bill in this committee because there be no notification to the firearm owners with protective orders. Without an amendment here directing the state police to give written notification to those you intend to self-disclose at the shelters, they will have no idea of this new requirement. In summary, those who need emergency shelters include all types, possibly gang members, drug dealers, users, stalkers, and thieves. Their rate of reoffense is extremely higher than those listed on the VSP registry, but this is still the one group of citizens that is targeted every General Assembly. Thank you.
Yeah, one second. Let me ask Steve. You and I have talked a little bit about the registry and burdens, and I just would be grateful if you'd talk for just a second about the validity of Mary's concerns about whether this adds any additional burdens and the impact of that. I think that it is important for us to step back and look at this.
Mr. Chairman, you're right, and so I want to sound a note of caution to the committee. This summer, the Pennsylvania Supreme Court declared unconstitutional Pennsylvania's sex offender registration procedure. And what the committee should know is that each time a measure is imposed, as well-intentioned as it obviously is, it has an effect on those who have already committed their crimes and been sentenced and are currently under the burdens of the registration system. And I say this because the committee is aware, I think everyone is aware, that generally speaking, ex post facto laws are prohibited. Those are laws which increase the punishment from the punishment that existed at the time of the offense and the sentencing. Regulations like this, amendments like this, are not designed to be punishment. But that doesn't end the question. The question is whether the regulations become so punitive that they override the legislature's intent to regulate and not punish. This small measure in itself is not something that I would say to you, this is going to cause the registration scheme to be unconstitutional. But the committee should know that each time it does something that affects people who have already been sentenced, not only does it further burden the efficient operation of the registry, as Mary alludes to, but it also creates a greater vulnerability that one day an attack on our system will be sustained. So a note of caution. If it's not necessary, you might want to think twice about effecting it.
And let me ask you about, and I think Mary said 5 days. I think this has a 3-day reporting requirement, state police. And I know we strive for specificity rather than ambiguous standards, but in light of her concerns about circumstances, would as soon as practicable language work?
What do you think?
Well, let me let you all cogitate over that for a minute.
Yeah.
Senator Peterson.
Mr. Chair, this is sort of a half question, half comment, but let me ask the chief of police, or while he's walking away. I mean, the second half of this bill, I'm going to assume this is a natural disaster like a flood such as we had in Houston.
That's correct.
And you're asking a person who's in a shelter, safely in a shelter where we want them to be, this bill is then asking them to go and register in person with the local law enforcement. So in person, as I understand, means you got to go out and you got to be walking into a police station. First, if it hasn't floated away at that point, you got to go find a police department, walk in there and say, you're busy saving people's lives, but just by the way, I'm a registered sex offender. I'm down here at, 34th Street Shelter. To me, this whole Part B is a little bit, it just doesn't sound practical.
Typically, the security for shelters rests with law enforcement, and that's why we're asking for notification on the scene. And that's in Part A. Part B portion, I understand, but I suspect that that issue perhaps requires a bit more clarification.
If by elimination you mean clarification, we might agree with you. But let me ask you a follow-up. What if they don't report? What if they stay in the shelter? I mean, are they going to be subject to a violation of probation? Are they going to be subject to a separate criminal penalty?
They could.
Can you, and I don't know the answer to this. Can you report by phone?
No,
Oh, in
it's in
person?
person.
Okay.
Sure. Yeah.
Does that help your concerns?
If section B is removed, it definitely.
How about by phone?
So registration today is not available by phone because there's
I
no
see.
24-hour line.
Okay.
Well, Mr. Chairman,
Mr. Chairman.
I have one other person, actually one of the attorneys that prosecutes these cases, who I'd just like to make
Sure.
a brief comment, please.
Mr. Chair, one of my attorneys, Carrie McCardle, came up this morning with the chief, and she is the assigned attorney in my office that prosecutes these cases and
Oh,
works
great.
closely with the state police, so she may be able to answer some
All
questions.
right, great. Welcome.
Good morning. Thank you for allowing me to speak today.
We're going to give you a chair up here next to our counsel so you can help work on this.
To answer your most recent question, you're correct. You cannot register by phone. And with regard to the question about the registration requirement after 3 days, offenders are already required to register any change of address within 3 days.
I see.
The code section says residing at a shelter, so therefore that becomes your residential address. So it's not adding any additional burden on the offender.
So to Senator Peterson's point, is that section B surplusage?
It could be considered that. I think, as the chief is saying, the more significant thrust of the bill is so that the staff of these shelters are aware that offenders are coming in, especially if it's such an extensive disaster that they don't have internet access.
Okay. I appreciate that, and I mean, that gives me a little bit more comfort and clarity. So Charles and Steve, do you all have thoughts as to how to strip this down to the essence of the patron's intent?
Mr. Chairman, we would strike the language beginning on line 18 with the word upon through and including the word shelter on line 22. And you would strike, if I understand the committee correctly, lines 25 through 31. That's subsection B.
All right. Is there a motion to that effect? So moved. It's been moved and seconded. All in favor of that amendment signify by saying aye. Aye. All opposed? That amendment is made. The bill is before us.
Thank you, Mr. Chairman.
Anything else that needs to be done?
Roll the bills together.
Let's roll the bills together into Senate Bill 49. And Senator Norman has moved to report the bills as amended. Is there a second? All right.
Mr. Chairman, just one brief comment before we do this. You know, it was mentioned about the Supreme Court of Pennsylvania. Look, the Eagles already won. Let's not worry about them anymore, okay?
Mr. Chairman, I mentioned to John about the fact as far as that when the sex offender is put into a separate location, I mentioned that my status for it allowed the family to go with him. Is there a problem with that?
This basically strips it down to its core so that shelter staff has maximum discretion to do whatever they deem appropriate for the safety of people in the shelter. Okay?
Yes, sir. Okay.
All right.
Mr. Chairman, I want to thank the committee for its work on this.
All right. Clerk will open the roll.
Ayes 12, noes 1.
All right. Thank you very much.
Thank you,
I
Mr.
appreciate
Chairman,
the
members of
help
the committee.
in getting this right.
And Senator Benjamin, thank you, as always.
All right. Senator Spruill, I think you've got a couple other bills.
Yes, sir. Mr. Chairman, while the chief is here, when strike SB 53, the chief said he did a little more prayer on that one. Strike that, please.
All right. Senator Stewart moves, Senator Norman seconds. My goodness. All in favor of striking the bill signify by saying aye. All opposed, that bill is stricken, 53.
Thank you, Mr.
So we're
Chairman.
going back to 52 now?
Yes, sir.
All right.
Mr. Chairman, 52, this provides that when a juvenile who determined by the courts to be a threat to the security and safety of other juveniles detained in a juvenile security facility, and that juvenile is transferred to the jail, to the regional jail with adults. The problem they're having is that they were putting juveniles in these facilities along with adults. So what we're trying to do here is to transfer to a confined to a jail or facilities for the attention of adults. Such adult attention facilities must be approved by the State Board of Correction of Detention. And what we are trying to do here is trying to that when you allow a juvenile who will not behave himself in his facility, that he's 13 or 14, they put him in the jail with regular jail or regional jail with an adult. And they were saying that you can't do that. So to really clarify that, I have Ms. Linda Bryant here, who is officer of the regional jail here to explain what I'm trying to say.
All right. Step right up. Happy to hear from you.
Thank you, Mr. Chairperson. Good morning, everybody. So I'm Linda Bryant. I was a prosecutor for about 18 years, former Deputy Attorney General, Public Safety, and about last year I went back home, and I'm now at the Hampton Roads Regional Jail as the Assistant Superintendent. And this, one thing that was pretty clear to me pretty quickly was now that the Department of Justice has begun enforcing the Prison Rape Elimination Act, we needed to make a change or suggest a change. PREA is codified at 28 CFR 115, and specifically 28 CFR 115:14 deals with youthful inmates. And that federal standard basically requires the same thing that the Board of Corrections requires, which is that if juveniles are going to be housed with adults, they have to be kept separate and apart. Our code section 16.1249 is currently written under subsection D, specifies that juveniles do not have to be kept separate and apart. Under code section E of that same code section, juveniles do have to be kept separate and apart. So this is essentially just an effort to clarify the law. This is supported by the FOP. I'm here on their behalf as well to speak in favor of it. It's supported by the Sheriff's Association. It's supported by the Virginia Association of Regional Jails. And I believe the Commonwealth attorneys have no position on this. And that's part of the issue is that PREA, the 28 CFR 115 went into effect back in 2003 or 2004. It was patroned by now Attorney General Jeff Sessions. Jails had about 10 years to get into compliance. That 10-year window or 12-year window is passed, and now DOJ is enforcing this. So I believe that the jails, for the most part, are already aware of this, and they've gotten ahead of it. It's just the statute is unclear. So what I found is that there are some state court judges that don't swim a lot in federal litigation in Section 1983 and pattern and practice cases. And with all due respect to the prosecutors, this is just, they don't have to deal with PREA. And so this law, and same with the defense attorneys in state court, this is just not something that has come up until now because the code section in Virginia conflicts with the federal code.
Does it conflict or is it ambiguous? And
right. Let me take a look at the specific language. I believe that it actually conflicts because it says that, thank you, Senator Sproul, it says that juveniles may, let me see here, it actually conflicts. It says, and need no longer be entirely separate and removed from adults. And so that's the clause that this bill seeks to strike, and to add another clause, provided that the facility is approved by the State Board of Corrections for the detention of juveniles.
okay. Anybody have any questions of the patron or his witness? Anybody wish to speak for or against this bill? And I don't think it creates any issues. I think the only question that we'd had was whether it was whether it was already existing law, and I think that this is clarifying, so. It's been moved and seconded the bill be reported. Clerk will open the roll. All right, the bill's reported. Thank you very much.
Thank you, Mr. Chairman.
Next, we have Senator DeStaff.
Mr. Chairman, members of the committee, good morning.
We've got Senate Bill 729.
So first, I'd like to, we have a substitute, and on that substitute, after we adopt it, Mr. Chairman, I have a couple of line amendments. The attorney. Let me just go to the attorney. Yeah, lawyers. And Mr. Chairman, I've got
Senator
some.
Stewart moves and Senator Howell seconds the adoption of substitute. All in favor of adopting substitute signify by saying aye. All opposed. Substitutes before us. Senator, go ahead.
And Mr. Chairman, I've got a line amendment where we're going to reinsert line 341 and 342 and delete line 343 and 344. In the editing, in the negotiation between the groups, we had one little mistake.
All right. You have that, Charles or Kristen? Who's got this?
I have this.
Okay. The amendments have been moved and seconded. All in favor of adopting the line amendment signify by saying aye. All opposed. The line amendments are adopted. All right, Senator, go ahead.
And Mr. Chairman, members of the committee, there's a problem that we're facing not just in Virginia Beach, but all over the Commonwealth. It's malicious and egregious wounding and maiming of animals. Sugar, who is a sweet girl, whose only crime was belonging to a family in which she ultimately was abused by one of her owners and punished his spouses. The husband hacked Sugar multiple times, and we saw the pictures last year in the head and back with a machete and chased her from their apartment. She's lucky to have survived, but because she survived, the owner could only be charged with a misdemeanor. The man went on to attack his wife with the machete as well. Senate Bill 729, all it does is make such torture, cruelty, and mutilation of dogs a Class 6 felony instead of a misdemeanor. So it's not based on whether the dog dies or not. It's the act itself that gets a penalty. Senate Bill 729 has widespread support from animal welfare groups, some of whom you'll hear from today: the Virginia Federation of Humane Societies, Virginia Beach SPCA, Humane Society of the United States, Virginia Animal Control Association, Virginia Alliance for Animal Shelters, Virginians for Change to Animal Legislation, PETA, and many, many more. I introduced our subject matter expert, Officer Megan Conti, and we'll turn over the mic to her.
All right. Well, and we've got some time limits, and we're going to start the clock. And those who wish to speak in favor of this fine piece of legislation would step right up, right behind the officer. Good morning.
Good morning, Chairman. Thank you, committee, for giving us the opportunity. My name is Megan Conti. I am one of the supervisors of the Animal Enforcement Unit in Virginia Beach. Sugar's case occurred in our city, and we do have photos for those of you who weren't with us last year to see if you'd like to see them. They are quite graphic, but they do show the injuries that Sugar sustained, and that included machete hits to the head in multiple areas and on her back. And this was a dog that was adopted from our shelter to this family when she was a little puppy, and she was attacked as an adult. And the evolution that she had to go through after this, because we could save her, and she was not euthanized, the way the code is currently written, it is outcome-based. So she would have had to have succumbed to the injuries or been humanely euthanized at the direction of a veterinarian in order for this to be a Class 6 felony. Because we were able to save her and treat her wounds, and she's gone through extensive counseling and training with a rescue group to save her and to be able to put her up for adoption again, it's a Class 1 misdemeanor. So I offer those pictures if you'd like them.
Yeah, not to the page.
Not, okay.
Right, got it.
Let me just take the back sheet out.
And how many stitches did she have to have?
The stitches were well over 50 stitches. I mean, there were numerous lacerations to her head and her body. I know our supervisory staff, she lived in our offices for multiple months because she had no trust of people. And it took building an extensive relationship with her. But all that we are asking with this code is to not reduce the code towards any other animal. It is solely to allow the code to be situational based versus outcome based. So it shouldn't matter whether we are able, with the technologies we have now and the medical advances that we have now, to be able to save this animal. That shouldn't affect the penalty that the person should sustain. So it just makes the egregious acts.
All right. Well, thank you.
You're
Anybody?
welcome.
Next, step right up.
Good morning. My name is Jillian Deegan. I'm an assistant Commonwealth attorney in Botetourt County. I'm also the attorney that provides all the animal welfare laws training for the Commonwealth Attorneys Association. I speak nationally on this topic. This is particularly interesting to me because one of the topics I speak nationally about is the suffering of animals. And when you look at the extreme suffering of some of these animals that are able to be saved and that live versus an animal that is killed quickly and doesn't suffer.
You all support the bill?
We do, Your Honor.
VACA? Okay, awesome, thank you. Next, we're about out of time, so step up and state your name and organization, support.
Thank you. I'm Terry Royal, the Commonwealth Attorney of Nottoway County, and I also support this bill, and I really appreciate the Senator at the last minute introducing those line changes because they are very, very important for the support of the bill. Thank you.
Thank you.
Mr. Chairman, good morning. Matt Gray with Humane Society of the
Morning,
United
Matt.
States. We support the bill.
All right, thank you.
Mr. Chairman, members of the committee, Bob Mathias, City of Virginia Beach. We've had this in our legislative package for 2 years. Hope you'll support it.
All right, thank you, Bob. Anybody else? Anybody wish to speak in opposition to the bill? Shocking. It's been moved and seconded to report and re-refer this bill to the Committee on Finance. Clerk will open the roll.
Mr. Chairman, members of the committee, thank you very much. Have a wonderful day.
Congratulations. We'll see you in Finance.
Ayes 13, no 0.
All right. Next, we have Senator Black.
Thank you, Mr. Chairman.
I think we've got Senate Bill 47 first.
We will have Senate Bill 47.
And Senator Black, this is the bill that you carried last year, which passed
Yes.
essentially overwhelmingly in both bodies, and dealing with female genital mutilation, and the penalty wasn't quite where you felt that the penalty should be. This elevates the penalty to a Class 2 felony. Is that basically what this does?
That is correct. And if I could just briefly, there was not a single vote against it in either committee or either house unanimously, and the governor had no difficulty with it. The only problem and the only issue that has ever been raised in the intervening year is a great deal of confusion over the penalty provision. Senator McDougal was kind enough to add a special provision that did make it clear that we could prosecute for malicious wounding, but it's just awkward and difficult for people to understand, and so I spoke with the women of the Global Women's Peace Initiative, and I promised that I'd work to fix the bill this year. This similar legislation is a felony under federal law. 26 other states have similar things. And what I have today, I've got several witnesses who would like to speak briefly, led by Angela Peabody of the Women's Global Peace Initiative, and Ola Mohammed, who is a board member, and then there's Christine Hedstrom, and I'd like
All
to
right.
just turn it over to them.
Great. Step right up. We'd be delighted to hear from you. Thank you for being
Senator.
here.
Good morning, Mr. Chairman and members of the committee. Thanks for having us here. I just want to start by defining what female genital mutilation is. It is the intentional removal of either all or part of the external female genitalia for non-medical reasons. And external genitals include the clitoris, the labia pubis, the urethral, and the vaginal openings. Some of the health risks on FGM, as it is commonly called, are hemorrhaging, infection, pain, post-traumatic disorder, problems using the bathroom, infant and maternal mortalities, problems conceiving, and sometimes death. In the Commonwealth of Virginia, according to the CDC statistics, there are close to 40,000 women and girls living in the Commonwealth today that are at risk of FGM being done to them in this Commonwealth. And the law, by changing it, amending it to a felony, will help to change the cultural practice as a deterrent. Because culturally, I can tell you that a lot of the people who practice this, they don't, a misdemeanor will not deter them at all.
Thank you. Thank you very much.
Thank you.
Yes, ma'am. And I apologize. We've got 3 minutes for supporters, and I know there are a couple other people who'd like to say something.
Mr. Chairman, members of the committee, I'm Ala Mohammed. I'm the board member of Ms. Peabody's foundation, Global Women Peace Foundation. We have an example. Prior to the law being passed last year, a father from Ethiopia in Springfield, Virginia, was chasing his daughter down the street attempting to cut off her genitals. A woman from Ms. Peabody's church, where she actually did the workshop and education, which is a very important thing that Ms. Peabody does as part of the foundation. She educates the communities on this practice. A member of her church shielded this daughter, this girl, from the father with her body and called the police. When the Fairfax police arrived, they did not know anything about FGM because the woman had attended a presentation on FGM a few years earlier that Ms. Peabody had done. She was knowledgeable about FGM and understood what the girl said as she was running. Since there was no law in place at that time, the father was released. So, and just like Ms. Peabody said, we need to raise it to a criminal, to a class 2 felony, so this can be more effective.
Well, thank you very much for your advocacy. Anybody else wish to register your support for this?
Good morning, Mr. Chairman, Senators. I'm John Mahoney, Commonwealth Attorney for Caroline County. I'm here on behalf of Virginia Association of Commonwealth Attorneys, and we strongly support this bill. It makes the offense consistent with aggravated malicious wounding, which we believe the injuries are in this case.
Thank you very much. Anybody wish to speak in opposition to the bill? Senator Norman.
Mr. Chairman, I would move to report and re-refer the matter to the Committee on Finance.
It's been moved and seconded. Clerk will open the roll. All right. Thank you very much. Next bill,
Ayes
Senator
13,
Black,
no 0.
is, I'm sorry, your bill reports.
Thank you.
Senate Bill 109.
Thank you, Mr. Chairman. There are amendments to this, and perhaps those could be reported.
Mr. Chairman, on line 47, after town manager, insert or his designee who shall be an individual employed as a public safety official of the locality.
Okay. Is that it?
That's it, Mr. Chairman.
All right. Senator Stewart moves. Senator Howell seconds the adoption of that amendment. All in favor signify by saying aye. All opposed. That amendment is adopted. All right. Tell us what your bill does.
Yes, sir. What this does, this is put in at the request of the Loudoun County Board of Supervisors. And, oh, I should mention also, Mr. Chairman, I was asked if we could roll in Senate Bill 122, Wexton, and
118.
Senate Bill 118,
Senator
Favola.
Favola's. Okay. Let's hear about the bill, and then we'll take action on that and its other disposition at the end.
What this does is it allows EMS and fire agencies which are doing background checks on juvenile volunteers to be able to access juvenile criminal records, which they cannot do currently. The problem that we've got is that our best recruiting is with young people. If they get started when they're young, they're likely to stay on and just continue. And about 1 in 5 of our potential applicants, people who look like they would be good candidates, about 1 in 5 are under 18, and we simply cannot do the necessary criminal background check. The amendment was suggested by the state police just to make sure that it's very tight. We don't want to give access to juvenile criminal records to anyone unnecessarily, and so this is very, very carefully limited in its dissemination. And I have with me our fire chief Breiler and our county lobbyist from Loudoun County, Jeff Gore. And now, I will say there's no opposition that we know of following the state police amendment.
All right, Senator Black, thank you very much. Let's hear from supporters of the bill.
Good morning. My name is Keith Brower. I'm the fire chief in Loudoun County. Senator Black did an excellent job of outlining this bill. We're simply trying to comply with the regulations that were enacted under the Department of Health in 2013 that require background checks for any new prospective member, career or volunteer, joining an EMS agency. We do the backgrounds locally. We have a local ordinance. I have my professional standards investigator here who does those backgrounds if you have any process questions. But as Senator Black indicated, we do have an aggressive program, as do many Virginia localities, to go out and target juveniles under 18. We have to get them early to capture their interest and keep them in our system. So we just feel to comply with the law, to comply with the regulations rather, we need this latitude to be able to have that information as we would with an adult member. Yes, sir.
Yes. Yes, sir.
How you doing? My name is Steve Van Winkle. I'm an investigator with Loudoun County Fire and Rescue. I've got 30 years in law enforcement experience. The last 12 years, part of my job is processing applicants, career and volunteer applicants in the fire and rescue system. The code as written right now requires all EMS agencies to submit fingerprints for criminal history for all affiliates of an EMS agency. As the law is written right now, the dissemination for criminal histories they're processed the same for adults and juveniles. However, we fingerprint them, we submit the history, but we can't receive the results for a person between 16 and 18 years old. So the law, we're complying with the code. However, we can't receive that and be able to submit the recommendation to OEMS whether the juvenile is eligible or not for EMS certification. Thank you.
All right, thank you very much. Jeff, anybody else?
Mr. Chairman, Jeff Gore on behalf of Loudoun County. Appreciate the chief bringing this to the senator's attention, and this legislation would be extremely helpful. Loudoun relies heavily on volunteers, and it has one of the largest combined professional and volunteer fire services agency in the Commonwealth, and it has been a disincentive to be able to enroll juveniles who show interest, and this would be extremely helpful. Thank you.
Okay. Let me just,
Mr. Chairman,
Senator McDougall.
I very much understand the issue. As I'm looking at the legislation, why would we also want to release it to the state health commissioner or their designee?
let me put a finer point on this and kind of add to this. You know, I happen to be pro bono legal counsel to our Harrisonburg Volunteer Rescue Squad. And my understanding is, and I can't remember exactly, but my understanding is they've got to get a background check approved, and I think it's State Emergency Services, perhaps, that does the background check. Am I wrong about that? I worry, and I represent a lot of small towns, not large towns, but very small towns. And, you know, what comes across town manager's desk, you know, in small jurisdictions, may not, they may not have the safeguards that other jurisdictions may have. I mean, is there a way that we can more tightly cabin this so that we're not opening up juvenile records to, I mean, this is a lot of people here that we're opening juvenile records to. I wonder whether council has any ideas, or you know, Jeff or somebody else has any ideas as to how we can lock this down, achieve the goals of Loudoun County, but also achieve, you know, the goal of protecting the records of juveniles that you know, we placed a high premium on.
If I could, sir, the way the system has been working previously, 2 years ago, all of the EMS agencies submitted fingerprints through local law enforcement agencies, and the results would be sent to Office of Emergency Medical Services, OEMS, and the records would be received there. The code was amended 2 years ago to allow local jurisdictions, such as Loudoun County, who wrote their ordinance, to also do our own fingerprinting. Our department specifically, Loudoun County enacted an ordinance. We applied through state police and FBI. We received, as a larger agency, our own ORI, and allows us to contract with state police. We do our digital fingerprinting and submit directly in our system. The small, and the results come back directly to our department through, I receive that through the Virginia State Police record system. If the juvenile or adult has an actual criminal history, I receive a printed version by mail. Smaller jurisdictions would still do their fingerprinting through local law enforcement and directly report it to OEMS.
So would you be happy if it just went to your Commonwealth's attorney?
They wouldn't even know who the fingerprints would be for. They would receive that and not know that it's an applicant for fire and rescue.
No, I mean, you all put your application in, and the information comes back to the Commonwealth's attorney, who has to coordinate with you.
That's not a practical solution, unfortunately.
All right.
It's too many steps, and we believe that with our local ordinance and the procedures we've worked out with the state police, the procedure is tight. All the records come back to a single point. They're evaluated. We notify OEMS, and those records are shredded. Yes.
Mr. Chairman, I understand your concern. That concern was expressed when we developed the legislation before you, and we worked with the state police. We were hopeful that the amendment that staff has read would get to your point of tightening it down. And if that, it satisfied the state police, but if it doesn't satisfy your concerns on that, we can keep working on that, because the intent is to very narrowly tailor who has access to this sensitive information, and the county is very sensitive to that issue.
Well, I mean, I thought the amendment opened it up further to the town manager or his designee.
Well, Mr. Chairman, county, city, or town manager is in the bill as introduced.
Yeah,
and what we were trying to do is say that the designee has to be a public safety official. Now, it could go right to the public safety official and wouldn't have to go to the county town manager. It could go right to the chief, the fire chief.
All right. Anybody else have any questions? Let me suggest that maybe you all step aside, and if Steve doesn't mind talking with the patron and his supporters and see whether we can, Charles, if you don't mind, see if we can't.
We're certainly not wedded to any particular language, and I understand the concerns, so any way we can limit it, I think would be fine.
Let's see what we can do.
Okay.
All right, we'll pass this by temporarily.
Thank you, Mr.
Next,
Chairman.
we've got Senator Surovell. I'm sorry, Senator Favola, you and Senator Surovell are both the net weight champions in terms of the volume of paper that you brought with you to this committee today.
I'll make you happy.
You'll make us happier?
With one of my suggestions.
All right, let's start cranking through. And Senator, I tell you what, do you mind if we do Senator Hanger first? He's got one bill.
No problem with that.
Senator Hanger has Senate Bill 40.
Thank you, Mr. Chairman, members of the committee. I have one bill that I'm hopefully will be quick. Last year, Mr. Chairman.
540, I'm sorry.
540. Mr. Chairman, last year I brought two bills to the Courts of Justice Committee. I normally don't bring bills. You passed one, and it was created a problem for me. I spent several days over in the House Courts of Justice Committee with that bill. I didn't intend to bring a bill this year because the bill that I had last year on spousal support was referred to the family section of the bar. But they came back with a good recommendation, Mr. Chairman, so I had to bring the bill. And this bill deals with modifications to spousal support for the payer. It has to do with a significant change in income of the payer spouse. And the family life section made what I think is a modest recommendation on this, which is embodied in Senate Bill 540. The operative part of the new language is on lines 137 through 173, where a section E is added, where it allows petitioning court for a modification of spousal support when the payor spouse reaches full retirement age. Relevant to that, I received a letter over the weekend, my Saturday's mail. I was home from a lady who was really upset. Her husband had been paying spousal support since he was in his 40s, and she and her husband were on just Social Security income, and was wondering if I could do anything so that she could get a hearing on that to reduce the amount of spousal support he was paying. And she shared then that her husband was 90 years old. So he's been paying this spousal support for 50 years and is now living on Social Security income.
All right.
That's the bill, Mr. Chairman.
All right, anybody have any questions of the patron? Let's hear from the family law section of the bar. See what they think of this.
Good morning, Mr. Chairman.
Good
Judge
morning.
Ryanson Evely from the Virginia Family Law Coalition. We appreciate Senator Hanger working with us over the last 11 or 12 months to look into this issue and come up with something that everyone could live with. What we found was that there were inconsistent rulings across the state with regard to modification of spouse support upon retirement. So this bill establishes that once a party reaches normal retirement age, that becomes a material change, and then addresses factors that the courts to look at once that petition is filed. It also addresses a lingering issue with a case called Driscoll versus Hunter that was interpreted to force the court only to look at the payor spouse's assets and not look at the payee spouse's assets. So it does both of those, and we're very much in support of that.
Okay. Anybody else wish to speak in favor of this bill? Step right up.
Good morning, Mr. Chairman. I'm Sam Brittingham. I support this bill. I pay permanent alimony, and I'd like to bring up a few points. 1 in 4 divorces today are to couples over 50.
Now, don't knock this off the tracks.
I'm sorry. 1 in 10 is over 64. According to the Center for Medicare and Medicaid Services, by age 65, 2/3 of the Medicare beneficiaries have multiple chronic conditions. As the number of chronic conditions increases, so does the need for hospitalization and doctor visits. Medicare does not pay for health care while someone's in jail. Instead, Virginia taxpayers pay for that. When Massachusetts enacted justice reform, rather than incarcerate non-violent alimony payers. They arrest them, release them, order them to appear in court or for a trial. They'll go home, live with family, go to work, pay taxes, and pay their own health care. Alimony reform was part of Massachusetts' justice reform. The changes have cut their budget 16%. Similar savings in Virginia would cut the justice budget by $500 million. When you're running a $1.5 billion deficit, that's significant savings. During the last legislative session, Virginia passed 1855, which allowed someone sentenced of a property crime to indefinite probation. The outcome of this is consistent with allowing a change of conditions at retirement. It's a part of justice reform. The population of people in Virginia jails 50 and older grew from 715 in 1990 to 5,966 in 2011. That's an increase of 734%. And because of truth in sentencing, the number of elderly in jail will continue to rise.
Right.
Within the group of people who this will benefit are men who are 67, 77, and 87 years old, who have heart disease, cancer, disability, diabetes, dementia, Alzheimer's, and they're incapable of paying alimony. Under 2061, they go to jail.
Now, I don't want to cut you off, but I get a sense that the committee might largely be in agreement with you.
Oh, thank you.
And
thank you for letting me speak.
Well, and I don't want to stop you, but I know a couple of members of the committee have a couple of questions, maybe for the Family Law Coalition.
Okay.
And I don't suspect this will change the direction that this fine bill is headed, but Senator Stewart.
Thank you, Mr. Chairman. Yes, ma'am. My first question is, can a judge already consider this?
They can, but as I said earlier, there were inconsistent rulings across the state as to whether retirement was a material change in circumstances. And so to avoid that, we felt that it was important to put that into the legislation to make clear that that was the intent. But again, even if it is a material change, the court has the discretion to rule, especially under the new factors, that there should or should not be a change in spouse support.
What do you mean inconsistent rulings across the state?
There were some judges that said retirement was a material change in circumstances and would allow for the review of spouse support, and some judges who would say no, that retirement is not a material change in circumstances, and so the payor spouse could not even get their foot in the door to have it reviewed.
Senator Stewart.
One final question. So if we put this in the statute, does this one factor now get greater weight than other factors because it's specifically set out?
I suppose there could be an interpretation of that, but that was certainly not our intent. Our intent was to just make sure.
I don't know.
And I don't know that either.
I don't do this practice, can't do this practice, but I am concerned about that. If now at some point, because we've set it out, it gets greater weight than other factors, which may be equally as important.
Well, we're not saying that nothing else could be a material change, but with the great amount of inconsistency and with the policy that there should be at least a look at the situation upon retirement, we felt that it was important to distinguish that.
All right, Senator Chafin.
Mr. Chairman, has the committee given any thought to the process of whether one who is contractually bound, whether this will affect that contract?
It will not affect someone who's contractually bound if there is no ability under the contract to modify support at all. Nothing will change. Now, Senator Surville has a change in a bill that he has that may come up and may address that.
Mr. Chairman. Senator Chafin.
One final comment. I see as the largest problem in my practice and the practice of others, individuals who become contractually bound with nothing in the contract speaking to it other than it's a final agreement, it becomes a final order, and those individuals are bound to those terms with no chance of ever modifying it.
And that's Senator Surville's bill.
Senator Peterson.
Yeah, I was about to echo Senator Chafin's point that should we look at Senator Surville's bill before we vote on this? I mean, are they are they compatible? Because I know I had a situation with a constituent who ended up killing himself who was
I
not
don't
able
think
to.
these are inconsistent.
They're not inconsistent. Okay, well,
Let's
I'm
do
just-
these one at a time. Anybody have any other questions? All right, bill's before us.
Move to report.
It's been moved and seconded. The bill be reported. Clerk will open the roll. All right. Huh? Oh, oops, sorry. All right.
Thank you, Mr. Chairman.
Ayes 13, no zero.
Bill reports. Thank you very much. Senator Black, why don't you put a wrap on yours? Let me ask, Charles, you have a suggestion for how we can lock down Senate Bill, is it 109?
Yes, it's 109, and the suggestion is on line 47 that we strike county, city, or town manager, and then after chief law enforcement officer, we would insert or his designee who shall be an individual employed as a public safety official of the locality. So this way, the information would go to the chief law enforcement officer or the designee of the chief law enforcement officer.
Only.
Only.
Okay. Does that satisfy concerns? Anybody have a motion to adopt that amendment? It's been moved and seconded to adopt that amendment. All in favor signify by saying aye. All opposed? And let me ask, that satisfies your constituents?
Yes, Mr. Chairman, it does.
Okay. All right, the bill's before us.
Mr. Chairman, I would move to report 109, rolling 118 and 122 in, listing Senator Black as the chief patron and listing the patrons of 118 and 122 as co-patrons.
Okay. All right, motion's been made and seconded. Clerk will open the roll. Oh, all right.
Ayes 13, no zero.
All right. Bill reports as amended. Thank you.
Thank you, Mr. Chairman.
Thank you.
All right, Senator Surville.
Thank you, Mr. Chairman. I think Senate Bill 85 is probably the quickest, given that this committee adopted it unanimously last year.
Oh, I wouldn't be so sure.
All right. Great. Wonderful.
Senate Bill 85. That was a joke, okay?
It was 14-1 in 2016 and 15-0 last year, unanimous off the floor. So this bill just makes the two different protective orders we have in the code consistent, that if you're going to get a protective order, there has to be some kind of record in writing that puts the respondent to the protective order on notice as to what the allegations are against them before they have to defend themselves in the protective order. Currently, that language only exists in the protective order for children statute, but not the protective order for adults.
Okay. Now, last year, I think that the Supreme Court had some questions about this. No?
The Poverty Law Center had some concerns about it because of a situation in Fairfax.
All right. Well, let's go ahead and hear from those who wish to speak in favor of the bill.
Mr. Chairman, Cheshire Anson Evely from the Virginia Family Law Coalition. We do support this bill. We think it's important for the respondent, when he gets ready to come and defend himself, know exactly what the allegations are. And if there's not an affidavit, there's no way for him to know, or his attorney to know, how to prepare and bring in evidence. So we strongly support this bill.
All right. Support or opposition?
Opposition.
Okay. Anybody else in support? Okay. Go ahead.
Okay. Well, first of all, this bill is not requiring an affidavit. It's requiring, if there is no affidavit, a summary of the allegations and findings by a judge. So is the victim, the petitioner, going to be impeached on the judge's summary of her allegations or findings? And I understand that Senator Surville is trying to uphold due process, and I'm all for that. So I would suggest check boxes, right? So finding that on or about such and such a date, respondent did commit an act of violence or force against petitioner, threaten petitioner, commit criminal sexual assault, etc. Maybe a couple of check boxes that the judge can just check off after the victim gives or attests testimony. Because in some of the more populous areas like Fairfax, what's happening is that people who don't speak English are being required to fill out, if they do fill out affidavits, those affidavits are going out for translation. They don't come back until days later when the petitioner is supposed to come back to court to request a PPO. So often they never come back.
All right, so, and let me ask, I mean, patron, I mean, what, and Family Law Coalition, I mean, what do you think of that? I mean, is this something that the Committee on District Courts ought to take up and modify its forms?
I think the Fairfax County Board of Supervisors needs to hire some translators. But,
well,
and because the language that I put, the language in the bill is the identical language that's in the protective order for children statute right now. I just took the exact same language of the protective order for an act involving a child, stuck it in the protective order for the act involving an adult. And as far as I can tell, this problem's only happening, I think, in one jurisdiction. I think it's a problem we can resolve locally.
All right.
And Delegate Leftwich has this on the House side also. I don't know if that means anything, but.
All right. Any member of the committee have any other questions? All right, bills before us. Second. Been moved and seconded the bill be reported. Clerk will open the roll. Okay. You're moving on.
Ayes 11, noes 2.
All right.
Thank you, Mr. Chairman. Second bill, I'd say we should take up to 614. I think that's pretty quick.
Let's okay, 614.
So this bill is all about, but for a comma, the kingdom was lost. This bill puts a comma in a statute, and that's all it does pretty much.
A little more language than that.
Oh, wait a minute. Am I looking at the right one? Oh, 615. I'm sorry, 615.
All right. 615.
Yeah, so this was brought to my attention by the Virginia Poverty Law Center, who said that there's inconsistency within our juvenile courts about whether or not they feel that they can do a payroll withholding order for spousal support only. So that is not child support and spousal support, but only spousal support. I checked with my localities, and in Fairfax, they withhold for spousal only, but in Stafford, they don't. Apparently,
Why don't we see if there is any opposition to this bill?
Great.
Anybody oppose this bill? I think this is a simple, clarifying bill. Anybody have any questions of the patron? If not, bill's before us. It's been moved and seconded that Senate Bill 615 be reported. Clerk will open the roll.
Ayes 12, noes 1.
All right. We'll go to 614 next.
615, you mean? Yeah, 14. Sure, let's do 14. Okay.
I'm sorry?
Sure, 614.
All right.
Okay, this is the one you all were just hearing some testimony about. So currently under Virginia law, if a property settlement agreement is silent as to whether or not spousal support is modifiable, there's a presumption that it is not modifiable. And I've had multiple cases come to my office over the last 21 years, including the one Senator Peterson referenced. I had the same constituent of his who contacted me about this issue legislatively, where people sign these contracts and they don't realize that what they're signing up for is non-modifiable because the contract doesn't state that. Most people who don't have lawyers don't know that. And so if the agreement is silent, you often get these he said, she says between their attorney and them about, well, the lawyer didn't tell me it was non-modifiable, et cetera. And all this bill says is that if you want spousal support to be not modifiable, you have to specifically state that in the agreement so that you know, you read it right there. This is not modifiable, and you don't get this he said, she said fight, and it's very clear. And I think it would clear up a lot of cases. The case, I can give you a cite, Newman v. Newman, 2004 was the Court of Appeals case that has the this would reverse but I think it's the right thing to do and would
All right.
reduce litigation.
Anybody have any questions of the patron? Let's hear from Family Law Coalition.
We actually oppose this particular bill, and I will tell, and I told Senator Surville, I think there is a technical flaw in the bill on page, or on line 44. It talks about being filed on or after July 1. I mentioned to Senator Surville that really should be signed or executed if the bill passes. So our position is that the law is very clear as to the non-modifiability of support once it's signed in an agreement. The parties have, it says it's paid. It doesn't have any change in there that it would change, and so there's no need to modify existing law.
All right,
Mr.
Senator
Chair.
Deeds.
I would move to, on line 44, to strike the word file and replace it with the word execute.
Is it, let's ask Kristen, is that executed or signed? What do we?
Executed would be appropriate, Mr. Chairman.
All right. It's been moved and seconded to make that amendment. All in favor of that amendment signify by saying aye.
Aye.
All opposed, that amendment is made. All right.
Questions?
Yes, Senator Peterson.
And this is for the lady for the Family Law Coalition. I had the same meeting with the person that met with Scott, and let me just quickly explain that situation. He had entered a divorce, I think about 10 or 15 years ago, and there was alimony was part of the divorce separation agreement, and that was executed as part of the final divorce decree, and was out of work, was unable to make the payments, and his ex-wife had moved to another state, I believe had remarried, or at least was living with another man, and basically had him locked up, and he was sort of in and out of jail for years. It really destroyed his family, and he ended up committing suicide actually after he had met with us, which sort of, cast a darker light on the whole episode. But the thing that was noticeable to me was typically, and I do contract law in commercial situations, I can sue people on contracts all day long. Unfortunately, if they don't pay, I can't put them in jail. This is a little bit different situation where a court can put somebody in jail. So I guess my question is to you, is it your position that if someone signs a contract where they stipulate to pay alimony, and are they automatically subject to jail if they lose work, if they're unable to make those payments? I mean, that seems like that's what's happening.
Senator Peterson, I appreciate the facts of that particular case, and it was an unfortunate case. I am familiar with it, both through Senator Surville and others. I don't think it's an automatic that the judge has to send someone to jail. The contempt part of the code doesn't require that. The court could look to see if the contemptuous actions were justified, and if there's an inability to pay, the court can take that into account and can choose not to incarcerate someone. It is an option. It's within the discretion of the court as to how they proceed at that particular juncture.
Mr. Chair.
Senator Peterson.
And again, reaching back to my days studying for the bar, because I don't touch domestic cases, but I always understood that there'd be if there was a material change of circumstances, you could change a divorce, a support order, for example. Is it currently you cannot change a contractually agreed amount of alimony? Is that what I understand?
Senator, you cannot change it unless there is a provision in the agreement that allows for modifiability. If there is no provision in the agreement, then the party is bound, both parties are bound for the duration.
Further question.
Further final question.
And then this will be done. So basically the point of his bill is to essentially say that it will be modifiable unless the agreement specifically says it's not modifiable.
That is the tenor of the bill.
Okay, thanks.
All right. Anybody have any other questions? Senator Sturtevant.
Thank you, Mr. Chairman. This is a question for the patron, and I'm trying to scan the text of the bill quickly. Is this going to be prospective only?
Yes,
Okay.
it would be unconstitutional if it was retroactive.
Okay, thank you.
Senator Chafin.
Mr. Chairman, a question for the patron. In your experience, do most of the agreements that you see have language specifically that indicates the agreement is modifiable if there's bilateral agreement?
Yeah,
Right?
most lawyers put that in the agreement,
Put that in
or else
there.
they'd be committing malpractice, probably.
Mr. Chairman.
Senator Chafin.
And have you seen clients that thought that meant they could modify their agreement? That came in with the mindset that they could modify their agreement because of that language?
Because it says modifiable.
Yes.
Yes.
Mr. Chairman.
Senator Chafin.
And in your experience, is the problem that the other side says, I have to agree to that, and I don't agree?
I think so.
Yeah.
All right. Anybody have any other questions of Atron? The bill's before us as amended. All right.
Move to report.
All right, it's been moved and seconded the bill be reported. Clerk will open the roll. Ryan. All right,
Ayes 10, noes 3.
bill reports. Next bill.
Could we go to 737? Mr. Chairman, 737 is a bill, has to do with ignition interlock. I would note for the committee that Senator Norman carried this identical bill 4 years ago when it passed this committee unanimously and finance unanimously.
Is that good or bad?
I'm not sure.
Okay.
Just one justice of the, or judge in the Court of Appeals once told me never to cite him to himself. That's dangerous.
All right.
Basically, what this bill does, Senator McDougal and I have had the pleasure to speak at the DMV Safety Conference for the last 4 or 5 years, where we go in front of all the judges and have some interaction about our current system. This basically says if you have a low BAC first offense DUI, and you have an ignition interlock on your car for a year, there's no other license restrictions. So none of this to and from work, to and from church, all that stuff.
And .149 is a low BAC?
Relative to what we see in court, it's 08 to 14 is, I'd say, lower. I think the 15s and higher are the ones that tend to be more risky people that often have drinking problems. And so that's, and also, okay. But every time I brought this up at the Judicial Safety Conference, we get spontaneous applause from the judges about eliminating the restricted license restrictions that are out there now that we have the interlock system in place. And I thought this bill was motivated by good policy goals back in 2014 with the changes we had last November. I'm hopeful that this might actually pass this year where it died last time. And so I thought it was a good time to have this discussion again, which is why I brought this bill. As I said, we passed it or you all passed it unanimously in 14.
All right. Anybody have any questions of the patron?
Mr. Chairman.
Senator McDougal.
I don't necessarily have a question, more of a statement.
Oh, it needs an amendment too, I'm sorry.
Go ahead, Ryan.
The statement is, I think what Senator Servell is trying to do is a laudable goal. We find in prosecutions for people violating a restricted license, it is only occurs if something else happens. They get stopped for another offense, there's an accident, that we are not finding people who are driving outside of their restrictions with any sort of normality. And so I think that this is one approach to deal with that. I have a bill that I think will probably come up Wednesday that takes a different approach that says if it's your first offense and you have ignition interlock on your vehicle and you also have a secure alcohol monitoring device that is constantly determining whether you're consuming alcohol. One of the negatives about ignition interlock is it only stops you from operating that vehicle when you try to operate a vehicle. But you could try to operate a vehicle that you don't own or possess, or you could continue to drink and nobody would know unless you try to operate a vehicle. So I think putting in an additional protection to make sure a person is not consuming the alcohol during that period of restriction would give me greater confidence. But I think what Senator Serval is trying to do is say, we're not catching people who are violating the current statute. It creates a tremendous amount of paperwork on the court system, thus creating some challenges. But I do think that there's probably an additional protection that would need to be in place to make me feel more comfortable.
All right. Let's hear whether there are people in support of Senator Serval's bill.
There's an amendment.
Let's come back to your amendment. Does it change the substance of it?
It changes the may to a shall. Right now, it seems to say interlocks discretionary, not mandatory.
Clerk.
It's on lines 34 and 213. We just need to change may to shall. 34 and 213.
Line 34.
And I think that'll make the Commonwealth attorneys happy.
Okay, shall impose. Okay.
Yeah.
Is there a motion to make that amendment? It's been moved. And seconded. All in favor signify by saying aye. Aye. All opposed? All right, that amendment is made. Let's hear from those who wish to speak in support of this bill.
Good morning, Mr. Chairman, members of the committee. Chris Legault for the Coalition of Ignition Interlock Manufacturers, and we do support this bill.
All right.
It reflects reality that people are going to continue to drive despite the restrictions. The restrictions are no longer part of any federal funding effort. They were removed from the last highway authorization bill in 2015, and we would encourage you to support this good bill. Thank you.
All right. Anybody else wish to speak in favor of the bill? Anybody wish to speak in opposition to the bill? All right. Bill as amended is before us.
Second.
All right. It's been moved and seconded that the bill be reported and re-referred to the Committee on Finance. Is that your motion?
Yes.
All right. All right. Clerk will open the roll.
Ayes 8, noes 5.
All right. It's getting closer.
Yeah, I figured that might happen.
All right, next bill.
Why don't we go to 610? 612 is pretty complicated.
610.
610 is the adultery decriminalization bill.
Oh, yes. Seen this before. Last year, it was passed by indefinitely in this committee on a 10-4 vote.
Right. That's right. And there was a lot of legal questions last year, which I had to answer some after the meeting was over. Delegate Leftwich is carrying this in the House this time, and you all should have received some emails from some more prominent family law lawyers in the state over the last couple weeks. The family law bar is 300% behind this, as far as I know. And just a couple points from last year. Virginia law prohibits the court from taking an adverse inference if somebody takes the Fifth Amendment. The court cannot do that. It's in the Code of Virginia. Adultery cannot just be alleged in every case. In an adultery case in Virginia, since 1895, you have to allege it with particularity. The name of the person who did it, the date, time, place. If you do it and you don't have the evidence, you can be sanctioned. And there's a reported case out of Fairfax sanctioning a lawyer who just noticed pled adultery and said, you know, it might have happened. We want to take discovery and look into it. You can't do this if you don't know the date, time, or place. You will get sanctioned by a court for doing that. Right now, this doesn't affect the Commonwealth attorneys. By amending it to a civil infraction, the Commonwealth attorneys don't have jurisdiction to prosecute civil infractions, so it doesn't affect them. And the Family Law Coalition, they're here as well. They're going to talk to you in a second, but there's universal agreement at the Family Law Bar. There's also cross-ideological support. The Family Foundation is here to support this. I had an op-ed in the Richmond Times-Dispatch last year, joint with Mr. Chris Friend, talking about our joint support of this concept. It's probably the first and last time you'll see me do an op-ed with them. But I don't know of anybody that opposes this bill, and I think it needs to happen this year. As I said, Delegate Leftwich is carrying it in the House, and we're both hopeful you'll act favorably on it.
All right. Well, let's hear from those who wish to speak in support of this bill.
Thank you, Mr. Chairman. The coalition does support this bill. We think it's an important part of being able to move forward and actually prove adultery. Under current law, because it is a criminal offense, even though it's rarely prosecuted, a party can plead the Fifth Amendment, and then we are forced to spend thousands of dollars to prove the adultery through other means. If you pass this bill, then the level of proof becomes an issue of preponderance of evidence as opposed to clear and convincing. You're going to save the parties and the Commonwealth time and money. You will allow the parties to go forward on grounds for divorce that affect the determination of property and also the determination of support.
All right. Thank you.
Mr. Chairman, members of the committee, Chris Friend of the Family Foundation in support, and I know that may bring a little bit of surprise to some folks on the committee, but when then Delegate Servo brought this bill to us a few years ago and explained the reason behind it, we did talk to a lot of pastors, a lot of marriage counselors, a lot of folks that dealt with this issue, and they were overwhelmingly supportive of this concept. They see the current law as a barrier to victims of adultery getting justice and be able to bring that in their divorce cases. So while you may see this as some type of decriminalization, it really isn't. It is going to allow for victims of adultery to get the justice that they would like.
Mr. Chairman.
Senator Stanley.
Mr. Chairman, question of the witness. Aren't you supposed to be in Texas?
Not
Aren't
yet.
you supposed to be going?
Not yet, no. This might be my last bill. Please pass it.
Mr. Chairman, I smell some charity coming out here. Mr. Chairman, I just want to say thank you to this gentleman for all of the advocacy and the time they spent. And he's been paroled from this opportunity to create a new opportunity in Texas. So we thank him. And so that I just want to give him a heck on the way out.
Thank you. Appreciate that. Thank you.
All right. Thank you very much.
Eddie Ayala, Virginia Assembly Independent Baptist. We don't have a consensus from my pastors about this. There was a suggestion that maybe we should bring back the stocks and maybe we could put people in the stocks and make some humiliation, but we would appreciate any type of move that would punish those who are guilty of adultery. Thank you.
So you support this? Kinda. Kinda.
Kinda.
All right. Senator Carrico, why don't we give you a call? Because you're after Senator Favola, and she has a fairly significant.
She's cutting some things. Yes, I'm withdrawing some.
All right. Well, we'll still call you.
Okay, thank you.
Yeah. All right. Bill is before us. It's been moved and seconded that the bill be reported. Clerk will open the roll.
Okay.
Ayes 4, noes 9.
All right.
All right. That's why I had it.
Do you want to just strike the last one? 612.
So the last one is 612.
Oh, boy.
Yeah, this one's complicated, but would bring Virginia into compliance with our Constitution. So 612 has to do with bringing Virginia's law up to speed with the I never know how to say it, Obergefell case with regard to assisted conception and our parenting presumption. So I had actually a Harvard law student who reached out to me this summer who is in a same-sex marriage with another woman, and she's pregnant. And because Virginia law does not afford same-sex couples a presumption of parentage when a child is born, same-sex couples have to do adoptions of children when a child is born instead of the child being presumed to be theirs. And so, in addition, there's with our surrogacy statutes, our surrogate parent statutes, there's a bunch of inconsistencies in those as well that need to be updated so that same-sex marriages are treated the same as heterosexual marriages, and we're not in violation of the Constitutional Equal Protection Clause in light of Obergefell. This woman I spoke to talked to me about the kinds of things that these couples now have to do because of this. She's pregnant, very pregnant, and is actually locating her housing as close to Washington, D.C. as possible so that if she goes into labor, she can get across the river to have her child born in D.C. Because if her child's born in D.C., she won't have to do an adoption. But if the child's born in Virginia, it'll cost her thousands of dollars in time and expense and record and paper upkeep and et cetera. And so what this bill does is it codifies and updates what's called Lord Mansfield's rule, which I didn't even know existed until I got into this, about the presumption of parentage. Lord Mansfield was some guy in England who came down with this rule that said you can't say a kid is not yours if it's born during your marriage. You have to actually present evidence and prove it. You just can't come in and say it to make a kid illegitimate. So in Virginia, that's been the common law rule. And so lines 13 through 51 update that for same-sex couples. Line 73 updates the legal standard for infertility because for assisted conception marriages, infertility was only assumed to be people that could have sex to have a child as opposed to same-sex couples. And then the rest of the bill mainly updates terms to make it clear that gender-specific terms are gender-neutral, so it changes things like husband or wife to parent. And that's basically what the bill does. It was looked at by the Code Commission. The Code Commission actually came up with most of this language as part of their aborted attempt to update the overall Virginia Code. That's where I think David Cotter pulled most of the language in this. And the Lord Mansfield piece came from the Uniform Parentage Act, which is updated in 2017. So that's what the bill does. It would save a lot of people a lot of headache and legal expense, and it would bring Virginia into compliance with our constitutional standards.
All right.
Mr. Chair.
Who's that? Senator Peterson.
Okay, I'm with you, Scott, but I have a question that you use the phrase 300 days prior to the date of their separation. Well, obviously, if you're husband and wife in a heterosexual marriage, it's because there's probably a presumption that it was conceived, but it would seem to me it would be different where you're borrowing that 300 days because you no longer have the same presumption for 9 months of conception.
Well, that's there to deal with surrogacy situations. So, for example, this woman I was speaking to, her and her partner went to a sperm bank and they went and figured out and chose, and then they did a contract with a surrogate. And so the 300 days has to do with the 9-month gestational period. And so that's where that comes into play. And the 300 days is a pretty standard, it's already in the code in a couple other places, I think, relating to, it's a pretty universally, the 300-day piece is a pretty universally used standard.
But that's because it's presumed that the couple had sex, and that's where the conception arrives from.
Right.
So this is not the same.
Well, I respond to him, Mr. Chairman? For surrogacy situations, it is, but obviously, this is designed to deal with surrogacy situations.
You're trying to be sufficiently expansive to cover everything.
Right.
All right. All right. Any other questions? Let's hear from folks who'd like to speak in support of this.
Hey, Chairman, James Parrish, Equality Virginia. These families already exist, and this bill is not going to change that reality. And what it's going to do is make sure that all families are treated in the same manner. Right now, we have same gender couples who have to navigate these processes in the courts, and they incur all these fees and the time just to ensure that their families have the same considerations and protections that opposite gender couples enjoy. And so Equality Virginia supports these efforts by Senator Servell to make sure all families have the same access to these protections.
All right, thank you very much. Anybody else wish to speak in support of this? All right, how about in opposition?
Mr. Chairman, members of the committee, my name is Josh Hetzler on behalf of the Family Foundation. No public policy should ever presume that a child born does not have both a mother and a father. Depriving a person of that right will have profoundly detrimental impacts on their life and psychological and emotional development. By passing this legislation today, make no mistake, that is precisely what you will be doing to future children in many cases. Some may tell you that such a change in the law is somehow required by a court decision. Whether or not that is really the case, I ask the members of this committee to consider which is the greater harm, disregarding the opinion of a court or intentionally and permanently depriving children of both a mother and a father and telling them not merely that one of them is no longer around, but that they indeed never had a mother or father to begin with. And moreover, relegating motherhood and fatherhood to nothing more than an unnecessary social construct. I need not answer this question for you because I suspect that each of you knows full well what the answer is. The truth is, however, that a court has no more authority to declare that a child has no relationship to a father than to declare that such a child has no relationship with gravity. To presume on behalf of a child that which defies reality is to impose upon them invariable and immeasurable harm. As members of the legislative branch of the government of the people of this Commonwealth, you have both an inherent right and a moral duty to serve as a counterbalance to the lawless actions of the other branches. If ever there was a time to exercise that authority, that time is now. Thank you.
Mr. Chair.
All right.
For Scott.
Senator Peterson.
And my mind's sort of zeroing in a little bit better. I'm still sort of on this 300 days presumption issue, because I understand if a heterosexual couple splits and then a child is born 9 months later, there's still a presumption that the child was conceived by a sexual act during the course of the marriage. But, and I support the bill, and I support having the same rights for surrogacy between same-sex and heterosexual couples, no problem. But this issue of a presumption, if you have a lesbian couple, they're married, then they divorce, then 9 months later, one adopts a child, is it the presumption that?
One gives birth to a child is what the 300 days would be.
Right, but as long as the child was born 300 days after the date of the separation between the lesbian couple, you'll still have presumption that those are the two parents. Even, I mean, I guess what I'm saying is, Scott, these are kind of apples and oranges when you get to that 300, what the 300 days actually represents.
You want to work on this?
You know, this language came from the Uniform Act, and I don't know who to send it to. I mean, I've talked to the Family Law Coalition about it. They don't have people. They've expressed maybe they should have people to deal with surrogacy and adoption in their group, but Boyd Graves doesn't deal with it.
I guess to me, I'll say one more thing.
And I'm not sure if going by for the week or something with the committee is okay with the policy in general.
Well,
right, I get that.
Mr. Chair, if you were to just take out the 300 days, I mean, just take out that presumption, which that may be valid for heterosexual couples, but just leave that out of this bill.
So strike lines 38 through 51.
Exactly. And then just otherwise leave it as is. I think that would just be simpler.
All right, you want to make an amendment?
I'll make that motion.
All right, give it to us again.
Just strike lines 38 through 51, I think is what he said.
Just strike the presumption on 300 days.
Mr. Chairman?
Sir McDougall.
Just before we get too far on this, so the way this is written, it applies to every single case. So you'll be changing,
Lord Mansfield's rules, the common law in Virginia, and this is a codification of the common law plus a tweak for same sex. So taking it out would just leave the law the way it is.
so, no, by putting this in with that amendment, you will be changing what the common law is. Yeah, because you'll be codifying something different.
No.
He's taking out the change.
No. Mr. Chair, if I might. All that
Senator
Scott's
Peterson.
bill would do, if you took out all the language on the 300 days, you're simply saying that there's a presumption that if a couple is married, that a child that is adopted, or excuse me, that is born into that marriage, they're the parents. That's all you want to do, Scott, correct? I mean, I know you want to do more, but let's, I'm trying to be your success coach here.
If you strike lines 38 through 51, the common law stays the way it is in Virginia and has been since we got out of England.
So is this what you added to the bill? 38 through 51 is what is left, the Code Commission recommendation?
Yes.
All right.
That's right.
All right, so we're stripping out your work product.
No, I thought.
Yeah, the Harvard law student who really wanted it.
No, hold on.
Cotter.
All right.
Yeah.
No, if you 38 through 51 is all, you just want 41 through 51, correct?
No, I think 38 through 51 ought to come out if we're not going to get into that Lord Mansfield rule at all, and just leave the common law the way it is and deal with Lord Mansfield later.
Okay.
Yeah. Yeah.
All right, Kristen?
Right, D&E.
Mr. Chairman, my understanding of the amendment is that it would remove section 20-49.1 and all of its amendments completely from the bill.
That would be even
Okay.
simpler. Yeah.
All right, is that your amendment, your motion? All right, is there a second to that motion? It's been moved and seconded to strike all of the changes to 20-49.1.
Yeah, that's
which would remove that from the bill.
Yeah.
All right, all in favor signify by saying aye. Aye. All opposed? All right, that amendment is adopted.
Mr. Chairman, just so the record's clear, the Code Commission they did all this work and then they never, I'm not on it, but it's my understanding they never actually approved it. They just sort of got there and then froze.
All right. All right, so the bill, was there somebody else who wanted to speak in opposition to the bill? Yeah,
Oh, yeah, I'm sorry, yeah.
We paused. All right.
Thank you, Mr. Chairman, members of the committee. Bill Ray with the Virginia Catholic Conference. We just wanted to make the point that generally speaking, the law does first recognize biological parentage for a number of important reasons and then moves from there in appropriate cases with determination of parental rights. It's a very complicated section of the code. The Code Commission wasn't able to reach consensus among stakeholders, much less understand all of the implications that these sort of changes could make. And so we would just encourage you to oppose this at this time.
All right.
Thank you.
Well, thank you very much. And understand Family Law Coalition has no position on the bill. Okay. And adoption attorneys aren't part of your Family Law Coalition?
Mr. Chairman,
It's just divorce?
Just divorce. But having talked to Senator Somerville this morning, I think we're going to expand the coalition to include adoption bills, since they are, or adoption attorneys, since they're coming up more and more before the General Assembly, and also assisted reproduction technology. So by next session, we should have some people on board.
And that's great.
Thank you.
All right. Anybody have any other questions? Bills before us.
I'd move to report as amended.
All right, there's a motion, report is amended. Is there a second? Seconded. Clerk will open the roll.
Ayes 6, no 7.
All right, bill fails to report.
Thank you, Mr. Chairman.
Thank you. Senator Favola.
Good morning, Mr. Chairman. I would like to strike SB 64, SB 66, and SB 75.
All right. Senator Howell moves, Senator Stewart seconds that those three bills be stricken. All in favor signify by saying aye. All opposed, those bills are stricken. So, what do you want to start with?
I'll just start with, I'll go consecutively with Senate Bill
39?
39. Yep. Mr. Chairman, what this does is in cases where there's an appeal regarding custody or visitation rights, and the appeal, of course, is going to the circuit court, it would remove the $25 fee. So it's very straightforward. The fee for servicing the process of the notice would still be in effect. There would be a fiscal implication because there'd be a loss of revenue. There'd be loss of revenue, and we're expecting that to be about $800,000. My intent was to remove barriers when it comes to.
All right, let me just ask you, and the $800,000 cost is not insignificant and may have some impact on what finally happens to this. But my understanding is that the filing fee can already be waived in cases of poverty.
Yes, sir.
So why would you want to waive the filing fee for people who can pay?
Well, I wanted to make it easier for people to appeal custody decisions if that was the case. I didn't put a means test in there. I thought, at the time, I thought $25 was de minimis, but when you look at the number of cases affected, it came out to be an $800,000 cost.
Okay.
So.
All right. Anybody wish to speak in favor of this bill?
Mr. Chairman, the coalition does support the bill. I've talked to Ms. Walsh about one section that was carried over from the other section, and that is on line 71, beginning with for purposes of the subsection. It doesn't seem to make sense anymore, and I know that was a carried over. So I would like for the committee to consider taking that particular sentence out, but otherwise we're in support of the bill.
Okay, we'll make note of that. All right, anybody else wish to speak to the bill? All right, there's been a suggestion that we take out on line 71 to 72 for purposes of this subsection. Is that right?
Mr. Chairman, it would actually be the entire last sentence, so on line 71 through 74.
All right. Is there a motion to that effect? It's been moved and seconded. All in favor of that amendment signify by saying aye. All opposed, that amendment is adopted. The bill's before us. There's a motion to pass the bill by indefinitely. Is there a second? It's been seconded. Clerk will open the roll. All right. Chap. Senator Peterson. All right.
Ayes 13, no 0.
All right. That bill is passed by indefinitely. Next bill is
Bill number 67, and Mr. Chairman, there's an amendment to this bill, amendment in the nature of a substitute.
All right. Senator Stewart moves. Senator Howell seconds the adoption of the amendment in the nature of a substitute. All in favor signify by saying aye. All opposed. That substitute is before us.
Mr. Chairman, the concept for this bill came out of a symposium that the Commission on Youth held, and it was the symposium, the topic of the whole thing was trying to avoid trauma-informed incidences and examining how trauma does affect children and families. And we were looking at best practices, and I have worked with the administration on this bill, but they have not yet taken a position. What this bill does is a juvenile who would be with a probation officer would, under my bill, have whatever statements would be made during a screening or evaluation or an assessment would not be used in the adjudication of the determination of, I guess, guilt or innocence. The intent is to ensure there's a free flow of information. We want youth to feel very comfortable in telling the whole story. But the bill does say in the amendment that if information is provided, it can be used in the disposition. So that would be in the sentencing of whatever, hopefully, treatment plan or combination of treatment and corrective action the court may determine. We believe this is a best practice, so we would ask that you support the bill.
All right.
Mr. Chairman.
Senator McDougal.
Just, I can see that there might be some valuable policy decisions of why you would want a juvenile to be candid in a screening, evaluation, or assessment. So I could see if we have that tightly drawn, that could be good. I'm not seeing the benefits for a person is served with a petition for, let's say, felony breaking and entering. They're served with the petition, they go through the intake office process, and they're put on, in essence, a pretrial supervision before their case comes to court, which allows them to go home. And during that time, the probation officer is checking in on that juvenile, and then the juvenile tells them something about the offense. What is the public policy reason for not allowing that information to come into court? Because right now, with the way this is written, it's only, the current law is during that intake process, the information doesn't come in. But if it's a week later or 10 days later, that information could come in. You're saying any communication with the pretrial officer or a probation officer doesn't come in, and I'm not understanding what public policy benefit that creates.
Well, I see, because you're looking at line 18 where I say during or after, and because we took that out.
We're looking at your substitute.
At your substitute.
Yeah, you're interpreting that to mean at any point it would be, I'm interpreting this to mean that it would have to be part of an official screening and evaluation or assessment to be protected.
It says including.
Mr. Chairman.
Correct, including a mental health screening. So my interpretation of my amendment confines the protection to an actual official scring or mental health evaluation.
Mr. Chairman, the words say statement made by a child, number one, to an intake officer or probation officer, or. So any statements made to an intake officer or probation officer never come in ever, any reason, the way this is written. I'm not.
I guess I'll have to ask the council because I have a different interpretation because it says, or to any other individual participating in screening, evaluation, or assessment. So I'm thinking that the situation you talked about would not be
Mr. Chairman.
excluded, but
That's
Senator McDougal.
That's not what the bill says. The bill creates two separate things. An intake officer, any statements made to them, it doesn't limit that statement at any time, or a person participating in screening, evaluation, of assessment. I'm good with me personally, I'm good with public policy, why we want a juvenile to participate in that screening, evaluation, of assessment. I like that language, but if you take out the during the intake process, you're saying that a probation or intake officer can never testify about a statement whenever it's made, and I have a problem with that personally.
Mr. Chairman, if Senator McDougal's interpretation is correct, I am happy to put back in language that would limit it, if that is the wish of the committee.
So, all right. So Charles, to do that, unstrike during the intake process on line 12?
That's correct, Mr. Chairman.
All right, Senator McDougal makes that motion. Senator Stanley seconds. All in favor of that amendment signify by saying aye. Aye. All opposed? That amendment is made. All right. Do you have people here who'd like to speak in favor of this? Anybody wish to speak in opposition to this? The Commonwealth's attorneys have any view on this? Yes? No?
Mr. Chairman, members of the committee, I'm Matthew Kite from King William County Commonwealth's Attorney speaking on behalf of the Virginia Association of Commonwealth's Attorneys. With the amendment to add in the during the intake process, the concern of VACA is that exactly as Senator McDougal was saying, that you will limit what the probation officer can talk about. In our jurisdiction, for example, the intake officer, the probation officer are the same person. There can sometimes be months or a month between intake and adjudication. They check in with them during that period, and anything that they say should be relevant to the court.
So with this amendment, do you have a position?
I think we take a no dog, or we don't take a position on it. That's
okay.
At that point, because it returns it back to what it was before.
Okay.
Mr. Chairman.
Senator Stewart.
Matt, can I ask you a question, please? Currently, under the law, do we use those statements in intake?
Yes.
Is there a provision?
Yes. For example, if they're not during the intake process.
No.
If they are during the intake.
If they are during the intake process.
Makes a statement during the intake process to either the intake officer or probation officer.
The current statute prohibits that.
Right. Is that allowable to be used at that point? Is there a policy on that today? I committed the crime.
The current statute prohibits that.
That's what I thought, but that's what I was asking, Matt.
But what happens is the probation officer checks in with the kid the morning of court, and they make a statement of some sort. That's not the intake process any longer.
So current law, Mr. Chairman, current law excludes the use of those statements if they're made during intake.
Yes.
Then why do we need this bill?
Mr. Chairman, because it would cover screening and evaluation or assessment. So we wanted to make sure, because our best practices now are moving towards a more complete evaluation of the student, or the juvenile rather, not just a
Mr. Chairman.
more traditional intake.
Mr. Chairman.
Senator McDougal.
I was not helpful to Senator Favola at the beginning. I'll tag it to be helpful
Okay.
now. Mr. Chairman, if you go through this process, what happens, juveniles are different than adults. For adults, the law enforcement officer or citizen goes to the magistrate, you get a warrant for most cases unless it's a direct indictment, and then it's served on you, and your Fourth Amendment rights kick in if you're in custody and there's questioning. On this, the case with the juvenile is different. The law enforcement officer goes to the intake officer, which is typically the juvenile probation officer, and in many smaller jurisdictions, Mr. Kite is right, it's one person. They're not different people occupying that same role. That intake officer, before they do a petition, oftentimes will have the child come in with their parents and have a discussion about the offense and what's going on in their life. And then the intake officer will make a decision to issue a petition or divert that case. And diversion for cases is an option for that intake officer. And that's why I think having those conversations with the intake officer or probation officer at the time of intake is important to be protected, because then the juvenile is having a real conversation with their parents, and the intake officer can come to the best decision about whether to issue a petition or to divert the case. What I think Senator Favola is trying to do is say, after that intake process occurs, the court will oftentimes order a mental health or substance abuse evaluation of the child as they're going through that process. That not coming in to evidence as guilt or innocence will hopefully allow the juvenile to be more candid with the substance abuse personnel. And that's why I think this is, when we amended it back, we're limiting it to screening, evaluation, assessment process, and it's narrow what we're excluding for coming in at guilt or innocence, and that's probably a good public policy direction for us to go.
Well, let me ask you this.
Thank you, Mr. Chairman. Thank you, Senator McDougal.
I don't live in this world, so I and practice in this area, but are there screenings, evaluations, or assessments other than mental health or drug assessments that would be excluded under this? Or would the purpose of the patron be achieved by saying in Little Romanet 2, instead of including during a mental health screening or assessment? I mean, it just seems broad. Now, I don't know whether there are unintended consequences in other meetings or events during which a juvenile may make just an admission in a fit of remorse, and that would be excludable, which I don't think is the intention of the patron.
Mr. Chairman, maybe if you wanted to, because current law, mental health evaluations are also prohibited. So that's the law today. I think what Senator Favola is trying to get at is likely substance abuse evaluations, screening, or treatment that's occurring from the time the petition is issued till we get to court. So if you put substance abuse, then you would not have competency evaluations, those types of other things that might give you some concern. So I don't know if that's what Senator Favola wants, but I think if you said substance abuse or mental health screenings, that might get 90% of what she wants.
So instead of including, it would say during a mental health or substance abuse screening or assessment?
That would be fine at this point. I think those two categories would probably consume most of whatever evaluation the juvenile court system would deem appropriate.
Okay.
I mean, again, the goal of the juvenile court is to be rehabilitative, so as much information, free-flowing information, where the juvenile does not feel any impediment to being truthful is a good thing.
Well, let me ask Commonwealth's attorneys whether that makes you feel any better.
So, Mr. Chairman, the addition would be to make it a mental health or a substance abuse screening?
It would say during, strike the word including, so that it would make it clear that it's only statements during a mental health or substance abuse screening.
I think the concern generally, though, Mr. Chairman, is that if a child says, for example, during any sort of screening or any sort of discussion, I'm addicted to heroin, I'm getting it from my parents.
Yeah.
The court needs to know that. And if it's not admissible at the adjudication, it's not admissible until disposition, as this is written. It might not be evidence of guilt in adjudication, but the court probably should know that as soon as possible. And if it's not admissible at adjudication, which is the first hearing, or until after adjudication, that's a problem for the court.
Well, isn't that current law? I mean, isn't
No,
that a
current-
problem under current law?
The current law is only statements made to the
Intake officer.
during a mental
Okay.
health screening or assessment.
I see. Okay, thank you. All right, I'm not going to make that amendment, that motion to amend. Steve?
Mr. Chairman, I have some concern about an unintended consequence, and I'm trying to imagine a situation where the child might need to or want to introduce a statement that the child made. And this would prohibit the child from introducing any such statement. To fix that, at the end of the substitute, you would insert unless offered by the child.
Okay. Anybody want to make that amendment? All right.
I'll make that amendment.
Senator Deeds, is there a second to that? No second. All right, bills before us. There's a motion to report, seconded. All right, clerk will open the roll. All right.
Ayes 6, noes 7.
All right, bill fails to report.
Ooh.
Thank
You for your time, though, and I do appreciate your comments. They were very helpful. Thank you, Senator
Yeah, tough
McDougal.
issue, and I think that there is some sympathy for your cause. I think it's just something we need to continue to look at, so.
Maybe I'll come back next year. Thank you.
All right.
My next bill is Senate Bill 70, and I do have an amendment in the nature of a substitute, and I expect will like this amendment. And I don't know if staff has distributed it, but.
Mr. Chairman, I'm sorry, I don't have that substitute.
I thought that you'd indicated Friday that you did not want the substitute.
Given the way the conversations, side conversations I have had prior to the meeting.
All right, we're going to come back to that.
Okay.
I'm sorry, but.
No problem.
We were acting on the information we had last week, so.
That's fine. I can reschedule for next week.
No, let's just get copies and we'll come back to you shortly.
Okay.
Senator Carrico, I think, is not here at present. Senator McDougal, why don't you do your one in which you have a four-legged witness? Yeah.
Thank you, Mr. Chairman. Senate Bill 402.
Sorry, Bill. All right, Senate Bill 402.
Mr. Chairman, I think we have.
Well, is that right? 402?
420, sorry.
420, okay.
My dyslexia kicked in.
And Senate Bill 402, I think, is going to go by for the day, right? Your transdermal monitoring?
Yes. Is it on the docket or?
Yeah, it was.
Okay. We can see where we get to it, however
Okay.
you want to do that.
All right. 420. Go right ahead.
Mr. Chairman, this bill is dealing with certified facility dogs.
And I'm sorry, Senator McDougal moves the substitute, seconded by Senator Stewart. All in favor, signify by saying aye. All opposed, the substitute's before us.
Thank you, Mr. Chairman. Mr. Chairman, for most of y'all know that beginning part of my legal career was as a prosecutor, and I did a lot of prosecutions with
particularly juvenile victims in a lot of pretty serious cases, including abuse cases, not only from strangers, but also from family members. One of the things that we have done as a legislature is try to make it easier for victims to be able to testify in those difficult situations. The biggest tool that we have historically used has been video testimony, which is occurring live. Defense has the ability to cross-examine, but the juvenile is in a different location. Mr. Chairman, this approach is adding another tool in that arsenal for the protection of witnesses as they testify, and it would allow the presence of a certified facility dog. Mr. Chairman, we have with us a certified facility dog right now, or a dog that will qualify. His name is Nomad, and he lives in Bristol, Virginia. You can see that dogs that are highly trained, this is a lab mix, traditionally lots of energy. My lab would be sitting in my lap. She'd probably be looking at y'all from the top of the podium. She's 9 years old, but she's quite spry in her energy level. But this allows that comfort for the witness as they're testifying. Mr. Chairman, as we've gone through the bill, and I'm certain that there will be questions, and there's not uniformity of thought that this idea is as great as I think it is, but we did build in some protections for the court as they're going through the process, the types of offenses that this could be used for, and the fact that the defense could use it for their witnesses as well. Mr. Chairman, the final thing I'll say about the bill is there is a notice requirement, so this could not be sprung at the 23rd hour. All the parties will know because there would have to be a motion filed. Final thing I will tell you, Mr. Chairman, is that this dog is currently in Bristol. So this is the area that they're doing it. Right now, Eric Olson from Commonwealth Attorneys Association is here. They also have a certified dog in Stafford that they're using with their witnesses. The code is somewhat silent on this. This would establish a procedure that courts would be able to look to as these become more prevalent going forward.
All right. Let's hear from witnesses who would like to speak in support of this bill.
Good morning, Mr. Chairman. I really appreciate you putting this on the docket for today and accommodating the dog, so the dog could get everything done in one day. I don't know if you've noticed that the dog has been here the whole time, sitting over here. I don't know if you can see it. There was actually someone who walked in and stepped on the dog while you were discussing another bill a few minutes ago, and he didn't even make a sound, so I was pretty impressed with that. The only thing I'd like to point out is that there were some concerns raised by Courthouse Dogs Foundation, which is an organization that trains these dogs all over the country, and they just want to make sure that the language is strict enough that people can't just bring in their own dogs to court. We don't want the process to be disruptive. We don't want it to be prejudicial, and so we want dogs that are well-trained, just like Nomad, and dogs that provide comfort, but at the same time don't disrupt the proceedings. So there is some additional language, but I'm going to defer to the senator about that. If that can be added, that would be great. There's one law in Arizona and one law in Idaho that kind of tightens up the standards for what kinds of dogs you can bring into the courtroom. That would be great. Thank you so much.
All right, thank you.
Good morning, Mr. Chairman. My name is Eric Olson. I'm the Commonwealth Attorney in Stafford County. Since 2011, we've had a courthouse dog. We were the first jurisdiction in Virginia to have a courthouse dog. I got exposed to it in 2010. I could talk for an hour about the value of this. Imagine, if you can, the worst thing that ever happened to a child, and not just the trauma for the event, but having to come to court and sit in a courtroom with strangers and talk about the worst thing that ever happened to them. And the comfort of a facility dog is immeasurable. As they go through the process, speaking at the CAC, talking to the prosecutor, talking to the investigator, being prepared, and then the final chapter to that, which is coming to court. I can't tell you the benefits that we've gotten for that. So I'm an advocate for the program. This is new territory 15 years ago when this started. And judges had to kind of make their way on their own. But there's a lot of precedent now in other states on how to do this. And the other, I guess I'd like to just follow up with what Ms. Cooper said about the certification. What we don't want is dogs that are not highly trained coming into court and being service dogs. And so I would advocate for a very high standard of training and certification. There are organizations, their whole business is training these dogs. The thing that you can't have is a dog that's accepted as a facility dog or a service dog in a courthouse that disrupts the proceedings. The only way to guarantee that is to have a very high level of certification. I just want to give you an example of the type of danger in not having that. I'm prosecuting a case now as a special prosecutor in Richmond County with a multi-time convicted felon. He walks around he takes everywhere he goes a dog that has a vest on. And he calls it his service dog. And he has gotten some sort of certification for somebody so that restaurants, anywhere he goes, has to let his dog come in. And so there's different levels of certification. I would encourage the highest level of certification for these dogs. That's what's going to make this program work. That's what's going to make us successful, because we just can't have that.
All right, thank you very much.
Mr. Chair.
Mr. Chairman.
Senator Peake.
Yes, for the witness, you just, Mr. Chairman, you said that you have a courthouse dog and have had a courthouse dog, but it seems to me this statute would go against your use of the courthouse dog because it says it has to have a relationship with the actual witness.
We just call our dog a courthouse dog because we start at the early stage with when we have our witnesses come in to speak with us and to speak to the investigator. Our dog is available, and we have actually had our dog come into the courthouse. But the judges have permitted that. Not all judges in Virginia do that. This code section would clarify the law to allow that. But don't say. I'm sorry.
Have they allowed that dog to come in with witnesses?
Yes.
And see, this statute says that the witness has to have a long-standing relationship with that dog.
Correct.
Would this statute not then prevent your courthouse dog?
No.
It's an established
the way it works in
relationship.
Stafford, Mr. Chairman, the way it works in Stafford County is whether it's our domestic violence victims or our child victims, through the process, as we're getting prepared for trial, that dog is introduced.
That's establishing the relationship.
That's establishing the relationship.
Thank you.
And that's what makes it successful when they come into court.
All right.
Mr. Chair.
Who's that?
Peterson.
Senator Peterson.
The defendant can also make this application, correct?
Absolutely.
Okay, so if I'm a really smart criminal defense attorney, which I'm not either, but I could say, you know, my client has been accused of the most heinous crimes, and how can I humanize my client in front of the jury? I know. I'll file a petition and have a dog sit on his lap while he's, answering questions about the case. In other words, I mean, we open this door up, and listen, I've tried a lot of cases in my career, a lot. And I've often been with my clients up on the witness stand trying to think of anything to distract the jury's attention from my client's testimony. Okay, I've been known to drop my keys. I've been known to have a cell phone go off mistakenly. I've tried everything. This might be the answer, because I get a four-legged dog in the courtroom. I got the jury looking at that dog and not listening to my idiot client.
Mr. Chairman, if I may, the jury never sees the dog. Each time that we have used our dog in the courtroom, the dog sits at the feet of the witness and is not a distraction. That's a very important aspect. The dog is a comforting feature for the victim. It is not a distraction, and these dogs are trained to be absolutely silent. Juries do not even know that these animals are there.
Mr. Chairman.
It's not in the bill, though, is it? Okay. All right, Senator Peterson.
That's all I have.
All right.
Mr. Chairman.
Senator Peake.
Sorry. The defendant can also have a companion dog under the statute, correct?
If the defendant testifies.
Okay. Thank you.
All right. I think somebody else wants to speak in favor of the bill. Yes, ma'am. And we're basically time, if you just register your support.
Yes, sir. Thank you, Mr. Chairman, members of the committee. My name is Sarah Noakes. I'm an assistant Commonwealth's attorney in the city of Bristol. Nomad is the dog that we use in court in Bristol. And so I'd just like to say that we have used Nomad for the past couple of years in Bristol, Washington County, and Smith County, the courts of the 28th District. We haven't had any problems. We've used Nomad several times in court. What we're trying to do is just open this up to the rest of the jurisdictions in the Commonwealth so that they may be as lucky as we are in having this accommodation for witnesses.
Has anybody objected?
Sir, the very first time I used the dog in court, I had a sort of a lengthy motions hearing, took about an hour long. We went through all the certification and training requirements that Nomad and his handler, Ms. Callis, who's here, went through to become a certified facility dog, and the court was satisfied that the dog was sufficiently trained not to disrupt the proceedings and to sit as you've seen him sitting here this entire morning, just like that.
Anybody object on the grounds of prejudice?
You know, I think we have to allow our courts to,
No, but has any criminal defendant objected to the dog's presence on the grounds of prejudice?
Well, that was the objection to the motion, right? It was saying, well, this is going to prejudice the court.
Right, I thought it was certification.
Well, we went through all those things,
Right.
and I'm sorry, you're right. There were multiple issues in that hearing. Certification was one of them. Prejudice was another. But as Mr. Olson said, you know, the members of the court or the jury don't even see the dog. He just sits in the witness stand, like down on the ground at the witness box.
Okay.
He's not even visible.
All right, well, thank you.
Thank you.
Let's hear from those who would like to speak in opposition.
Good morning. Maria Jankowski, Virginia Indigent Defense Commission. I have some concerns that I've expressed to Senator McDougal, some of which I think could easily be addressed if the dog's presence was not known to the trier of fact. My concerns are the, potential almost bolstering of the witness. I mean, it validates that the trauma is in fact there, that it is a real thing, I think it validates that the incident occurred, and there could be a case in which the fact at issue is, did this incident occur or not whether or not this particular defendant did it. I'm concerned about the definition of what an established relationship is. When I saw certified facility dog, and I have an autistic nephew, and we looked into getting him an actual service dog, and that dog would be with him at all times. So that's clearly an established relationship, and that dog has a clear, and that doesn't give me any cause or concern, because that dog is with that child all the time. This is something that's being introduced for the sole purpose of making that person a better witness. And that gives me concern as well. But primarily, I mean, the dogs are adorable. And the trier of fact seeing that is highly prejudicial. I don't want to say it could impact confrontation clause, but I wonder if it couldn't be raised. A good defense attorney might want to do that as well. So those are my concerns.
All right. Thank you. Anybody else wish to speak in opposition to the bill? All right. Let me ask Mr. Benjamin. We talked about this bill a bit in our work group, and I'd like him just to talk a little bit about some of the issues that were raised and that he may have.
Some of the issues to be discussed when you have a bill like this is the nature of the accreditation, whether there are any standards that will be applied, the nature of the witness for whom a facility dog will be used. Many of the states that have passed legislation restrict it to witnesses who are younger than 18 or to witnesses who, because of some specific condition or disability, have a hard time. I think that the committee has heard how a dog such as this is properly used. I think it sounds as if Eric Olson does it exactly the way it's supposed to be done. A couple suggestions would be, first, I agree with Senator Peake that lines 21 and 22 are confusing. I think somebody reading that could argue reasonably that they should be permitted to bring in their service dog as opposed to a facility dog. I don't think those lines are necessary to the bill. I think that those agencies that use facility dog, such as Eric's, are doing it correctly, and they will establish the necessary relationship. So my first suggestion would be that 21 and 22 are misleading and can be deleted from the bill. Moving on.
No problem.
Let me see what the patron says about that first.
That's the number 2, established relationship section?
Yes.
Yes. I don't see any reason why we couldn't do that.
Line 21 and 22.
Yes.
Is there a motion? All right. Second to that motion?
Second.
There's a motion to strike the language on line 21 and 22. All in favor of that motion, please say aye. Aye. Opposed, no. The ayes have it.
Moving up to accreditation, there is a nationally or internationally recognized organization called Assistance Dogs International that has the training programs and has the standards that have been alluded to. I would suggest on line 11 of the substitute, changing the word "or" to the word "and then on line 12, after the word "program," inserting accredited by Assistance Dogs International, striking the words beginning of on line 12 down to environments on line 13.
So moved. That's consistent with the language I handed. Yep. So moved.
Is there a second to that? Second. Motion properly seconded to amend it as just reported by Mr. Benjamin. All in favor, please say aye. Aye. Opposed, no. The ayes have it.
The other suggestion I have to mandate the concerns that have been recognized would be to add what would now be a new 3. You've deleted 2 at lines 21 and 22. So on line 23, that 3 would now be 2, and then you would add a new 3, and it would require that the court make this finding. The presence and use of the dog will not interfere with or distract from the testimony, the proceedings, or the parties and their counsel.
One more time, please, Steve.
This new language would require a court to make a finding, along with these other findings, that the presence and use of the dog will not interfere with or distract from the testimony, the proceedings, or the parties and their counsel.
Mr. Chairman.
Senator McDougall, how do you feel about that?
You know, I think proceedings and testimony is good. Parties are their counsel. That would, in essence, give, I think it could be argued that one counsel or the other could say this interferes with me, and that would give them a de facto veto. So I think Mr. Benjamin's articulation about proceedings and testimony in a court determining that it's not interfering would be sufficient enough to cover what he's trying to do. But I think if you say party or counsel, that could.
Mr. Chairman, I should explain a little bit more. First of all, just saying it interferes is not going to suffice. A court will not find by clear and convincing evidence just upon a say-so that it's going to interfere. A court will ask, how does that interfere? And my particular concern is I know defense attorneys, and presumably prosecutors as well, who are deathly allergic to dogs. And my concern is that there may be a situation where the presence of a dog in a courtroom might take out an attorney or one of the parties. That's my concern.
Mr. Chairman, I would argue that the language interfere or distract from the proceedings would cover that situation.
Senator McDougall, can I ask you a question?
You can.
Do you believe under your bill that the court already has the authority to make this finding without reciting it in the bill? As I read the bill, it says the court may enter an order authorizing. And then you've got to make these limited, the court makes these limited findings, but it doesn't say that the court can't evaluate all these things that Mr. Benjamin was just saying. So I don't see why we need it in there, frankly, but perhaps you all look at it differently.
Mr. Chairman, I would agree that the way the bill is currently drafted, without any of the amendments, the court has the discretion. It's
That's
may,
what I
it's not
think.
shall.
Perhaps other members look at it differently, but I think the court retains the discretion without setting that out.
But, Mr. Chairman, I don't know that there's a danger if you add in proceedings or testimony. I do think if you add in parties or counsel, that could go a little different direction. But I think in the example that Mr. Benjamin articulated concern about, if a attorney was not able to participate in the proceeding, that would certainly, because of an allergic situation, that would certainly qualify as interfering in the proceeding.
Mr. Chairman, I think he's
I
right.
agree. I agree. All right, does anybody want to move that limited amendment? The presence and use of the dog will not interfere with or distract from the testimony or proceedings, period. Is there a second to that? Motion properly seconded to amend the bill. All in favor, please say aye. Aye. Opposed, no. The ayes have it. Okay. If no other questions or amendments, bills before us. Is there a motion?
Move to report.
We got a second? Motion properly seconded to report the bill as amended multiple times. Clerk, please open the roll.
Ayes 9, noes 4.
Bill reports 9-4.
Thank you, Mr. Chairman.
Let's see, Senator Carrico?
Morning, Mr. Chairman. I have several bills here, and we'll just start.
Which one would you like to start?
We'll just start out with 497 and tell you how that got put before us.
Senate Bill 497.
This is dealing with disorderly conduct in a public place and the right to detain those individuals. In the recent months past, you've seen the number of church shootings that took place. The sheriff contacted me in Grayson County and asked me if I could look at the possibility of being able to detain an individual at a church, much like they do a shoplifter at a store when someone shoplifts. Right now, if someone were to enter a church that would be disruptive, there's nothing that says that civilian or that security team that this church puts together. A lot of churches now, and you can talk with the state police and local agencies that are going in and doing security assessments of churches, are putting together security teams. But if you have someone who comes in there that's disruptive and the police are not on the scene or part of that security team and it's only civilians, there's no legal way that they can detain that individual. And this law, this change to this law would simply allow in a public place such as the churches to be able to detain that individual till law enforcement arrives.
Okay. Any questions of Senator Carrico with
Mr.
regard to this bill?
Mr. Chairman.
Senator Peake.
Do we not have anything as a citizen's arrest?
You can arrest as a citizen, but you can't detain them. You have to go before a magistrate and obtain a warrant.
You cannot place somebody.
Unless it's a felony situation.
Felony you can. Misdemeanor you cannot.
No.
Thank you, Mr. Chairman.
Any other questions of Senator Carrico? If not, Senator Carrico, you have any witnesses on this?
No.
Is anybody who'd like to speak in favor of this bill? Anybody who'd like to speak in opposition to this bill? Anybody who cares?
I care.
I know you do. I know you do. All right, what's the pleasure of the committee?
May I ask a question, Mr. Chair?
Senator Peters.
Unlike having gone to college and sort of been in a situation where I was around disorderly people, myself accepted, of course, can you just sort of walk me through, Senator Carrico, how this would happen? I mean, if you, for example, have a party next door, or
well,
how does this work?
I'm mainly interested in a place of worship. I don't know how you designate that or carve it down to just that, but I'll give you an example. Chat Peterson comes to my church, which I'm a part of their security team. You walk down the aisle and you're yelling at the pastor that you don't agree with his sermon and that and I'm going to tackle you in the middle aisle.
Okay.
And because you've not committed a crime at that time, but you've disrupted the service, disorderly conduct, there's no other law enforcement officer there if there's not one. I can't just detain you until law enforcement arrives. I have to let you go, see you to the door, get you out of the church. And then you may come back with a gun and take matters into your own hand. This way, that security team that's set up by that church, an individual would be able to detain that person until law enforcement could arrive. Now, if you're talking about a situation at the college, at the dormitory, same would apply, but I don't know how far you want to extend that. That's
Well, further question, Mr. Chair.
Senator Peterson.
Let's say a bouncer at a bar.
Mhm.
We don't have bars in Virginia, but restaurants that serve alcohol. And there's a bouncer and maybe there's a dispute, maybe there's a fight, maybe there's an argument, and they take that person and said, "Oh, you're out of here."
right.
In this situation, would they be actually able to hold them for an hour?
Yeah.
Okay.
Mr. Chairman.
Is that all, Senator Peterson?
Mr. Chairman.
Senator Stanley.
When we talk about, to the patron, when we talk about methods of detention, of detaining that person, what do you envision in that occurring? I mean, holding them on the ground, full Nelson, half Nelson, headlock, noogie, gun?
I think there's, if you got a gun, I'm going to have one, but it's, I'm going to meet the resistance that I'm meeting. And yeah, our security team at my church, I carry the gun. So I think that there's going to be different methods. I think, I even have the handcuffs if I have to use them. I just think that I think that right now with the height of the concerns of most churches, and a lot of churches in my area went to the sheriff concerned after the Tennessee shooting, that there's no method to detain these individuals until police arrive. And a lot of the churches that you and I represent are way back off the beaten path. And it's getting to a point that their congregation is getting nervous that there's no way of detaining someone that come into that building.
Mr. Chairman.
Senator Stanley.
Thank you. And I understand the church position on this. I certainly do. What concerns me a little bit here is, under disorderly conduct, as you know, as a former state trooper, it's just, disorderly conduct seems to be the catch-all charge that we see when they can't find anything else to charge them with. But two things. This also involves public intoxication. So are we holding, let's say somebody's just drunk and obnoxious, and it's not limited to a church. It can be anywhere in a public place. This bill would give the person who determines, that citizen determines that they're violating the statute, the right to hold that drunk person at gunpoint, potentially?
Well, depending on what method of detention you're talking about, I don't know that many people would hold someone at gunpoint to detain them just because they're drunk, but I don't know that they wouldn't.
Right.
I don't know that there's any way to do this other than the way it's in this section to relate to a place of worship. I'm only concerned about a place of worship, no other public place that I'm concerned about. I feel like the current situation and atmosphere that we have today with the shootings that occurred in Texas and Tennessee. Tennessee was the closest one to us that brought the hype of all the churches saying, what can we do? How can we detain? How can we prevent this person coming back with a gun and shooting us? The only way that I knew that the sheriff consulted me about was to give them the latitude to detain this individual until the police arrive. Now, a lot of churches have police in them, so it's going to resolve itself. But the ones that don't are in a situation where it could happen.
Mr. Chairman.
Senator Stanley.
And Senator Carrico, you're my seatmate. You're one of my best friends, probably the only one I have here. And, well, the only one that.
I was gonna say.
The only one that will admit it, anyway. But, I think I see where you're going with this. I just think it's so broad under the section that it just opens the Pandora's box for many potential incidents that would not work as favorably and wouldn't drive to what you're getting at.
I probably wasn't here for the discussion. It applies to bars too, doesn't it?
Applies to everything.
Bars over.
All right. All right. Bills
I'm just
before
doing
us.
what I was asked to do.
No, and I commend you for
Senator
it.
Sturtevant. I'm sorry, Senator Stanley, you finished, or?
Yes.
Senator Sturtevant.
This is a question for Mr. Benjamin. Is there anything in the code that defines what detaining might be under this section? I don't see it here. And then I guess the other question is whether or not would the detainer, the person detaining, be able to use force, presumably, in furtherance of this being allowed to detain someone for an hour under the statute?
I don't know, Mr. Chairman, of a statutory definition of detention in the code. And the answer is yes, a person would likely need to use force in order to effect a detention.
All right.
Mr.
Bills before us.
Mr. Chair,
Senator Peterson.
with nothing but love for Senator Carrico, I'm gonna move to PBI.
All right. It's a motion. Is there a second? It's been moved.
Would that be
Senator
defined as
McDougall.
tough love?
I think we all understand what Senator Carrico is trying to do. Could we be a little more gentle, and I would move that it be carried over for the year.
All right, substitute motion? Second. All right. Substitute motions before us, carry the bill over for the year. Clerk will open the roll.
Ayes 13, no zero.
With great affection.
Thank you.
You just said that because he's so big, didn't you?
Well,
You're right. Senate Bill 500.
Mr. Chairman, another request, Bill.
You want the motion right now?
Well, I think it merits a discussion just to tell you how it got here. There's in law enforcement, there's the investigations that go on with child pornography, and one of the problems that law enforcement has ran into is when you have a victimless crime. In other words, you have a individual viewing child pornography, but yet you can't find the child that was involved in the crime. You have a situation where in jurisdictions, not all, but in some jurisdictions, the juvenile court doesn't want to hear it because there's no victim to it. And then the general district court doesn't want to hear it because it should be in juvenile court. This simply puts it in a court in which it just specifies which court it needs to go into, and it takes away the long process of bouncing from one jurisdiction to the other of the court. I'm just trying to tell a judge what to do.
Mr. Chairman, are all or most, if not all, general districts and JDR courts cross-designated? I know in most of, particularly my rural areas, they all are because there might be a general district court that meets on one day when there's no JDR court, and particularly for purposes of arraignments, they all cross-designate. So isn't that the way to solve this issue, is to have a cross-designation between the courts instead of to be statutory?
Charles?
That's a good question.
Mr. Chairman, that is certainly possible. I understood from this bill that part of the problem is also that law enforcement would go to general district court and it wouldn't be on the docket. And then they would go to general district court and it wouldn't be on the docket. So some of it is as it relates to what court they need to go to, not necessarily the jurisdiction of the specific court. Seems like the clerk should be able to deal with that.
I don't know that it's harmful, but I don't know that it
Yeah, I
helps
don't know.
anything.
All right, you have anybody you'd like to speak in favor of this? Be interested in what the Commonwealth Attorneys Association thinks.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth Attorneys, and we're still scratching our head about this one because the only offense that we can think of that involves a child whose identity we don't know is child porn. And one of the elements of the offense is that we have to prove that the picture is of a child, and therefore, whether we know the identity of the child, we're going to have to prove that this is someone under the age of 18, which is going to put the jurisdiction in the J&DR court. I've been sort of scratching my head what other crimes might be associated. We might not know the identity of the child, and I just cannot come up with anything. So I don't mean to do the bill any harm, but I don't see where the bill does anything at this point in time, other than maybe address one court in one jurisdiction where they're doing this number here.
Senator McDougall.
Doucette, are you finding that most JDRs and general districts do have that cross designation?
I can't speak for the Commonwealth, but I can certainly speak for our area in Lynchburg, and yes, they do.
All right. Anybody else have any questions? Anybody want to speak in favor of the bill? In opposition of the bill? Come on.
Camille Cooper with the National Association to Protect Children, and we oppose this bill. I had extensive conversations, and my apologies to Senator Kirkle. I really like him. I just don't like his bill.
So does my seatmate.
I had extensive conversations with the state police. As you know, we're pretty involved with the Internet Crimes Against Children task forces, and there appears to be one particular officer who is concerned about court efficiency. And I appreciate that, but I wish that we could legislate all kinds of efficiency, and we can't. And my greatest concern is that if you force all the child pornography cases into the juvenile and domestic relations court, you are going to have to add an additional element to that offense, and you're going to have to prove it was a child. And sometimes we know it's a child, but we can't prove it's a child. So for those reasons, we oppose this bill.
All right. Anybody else wish to speak to the bill? The bill's before us. All right. It's a motion. The motion before us is to pass the bill by indefinitely. Clerk will open the roll. All right, Senator Carrico.
Ayes 12, noes 1.
All right, 508.
Okay, this is one that's not by request. This is one that I actually thought up myself.
Oh boy.
That's a grill introduction. So anyway, this is a bill that is trying to address some of the issues that we have, especially on I-81. As you all know, we have entered into the 21st century, and we have what's known as unmanned aircraft systems. And this is a way now with the computer systems that the state police have in their car that we can allow the Department of Transportation and state police to communicate by using these unmanned aircrafts to photograph and to take video information from the scene of a crash to where the law enforcement officer that may be working a crash on the other end of the interstate, the crash doesn't have to shut down the interstate for such a long period of time for him to get there, to take pictures, to do all the things he's got to do in order to do the investigation of that accident. This will give him real-time images of what the accident is and give him the photographs that he needs, and then the accident can be moved off the highway into the shoulder and even cleaned up at night when the traffic is not so heavy. This just gives the authorization to the state police and the Department of Transportation to use the unmanned devices to do that, to hopefully open these scenes up quicker than to delaying and costing the Commonwealth so much money.
All right. Anybody have any questions to the patron? Anybody wish to speak in favor of this bill? Yes, sir. Yes, ma'am.
Good morning, Michelle Satterland on behalf of the Unmanned Systems Association of Virginia. We do support this bill. We believe it removes barriers to the use of unmanned systems, which are more efficient and cost-effective. We believe will save the state money.
All right, thank you. Yes, sir.
Good morning. My name is Dean Gustafson, our State Operations Engineer for Virginia DOT. We strongly support this bill. We know that fatal crashes are a problem here in Virginia. The average fatal crash takes about 4 hours to clean up, and that is a tremendous impact to our transportation system when the road is closed during these investigations. Last year, we had 790 deaths in Virginia, and this technology could certainly be used to help expedite its clearance. Want to note that on our interstate system, we experience a lot of delays associated with these crashes, over 1,000 of delays, 1,000 hours of delay, and the economic cost of these delays is $45,000 alone. And when you add up all the serious crashes and fatal crashes in Virginia, you'd have over $17 million in cost. Maryland is one of the first state DOTs, or Maryland State Transportation Authority, that has used unmanned aerial systems for fatal crash reconstruction, and they believe, along with state police, they can reduce the crash time down to clearance time down to 2 hours. So taking from 4 hours to get the road open to 2 hours, we think is strongly supported and can help limit secondary crashes. Thank you.
You done? Okay. All right. State Police, yes, sir.
Mr. Chairman, Keenan Hook, State Police.
I don't like this,
we support
do
the
you?
bill. Yes, sir. We thank Senator Carrico and the Department of Transportation for pursuing this.
All right, Senator McDougall.
Mr. Chairman, I like the concept, so I'm not trying to cause damage, but the way Section D is worded, we're saying that this is not a law enforcement purpose. Wouldn't it be better to say, to have Section D have a warrant is required except and listed out as an exception instead of saying it's not a law enforcement purpose? Because I think at some point, if there is a fatality or even discharge of reckless driving, it is in fact a law enforcement purpose going to be used in a criminal proceeding. So
Sounds good to me. I think.
I'm okay. I think we should exempt it from the warrant requirement if it's being used by DOT, but I don't know that we should be intellectually dishonest and say it's not law enforcement purpose. That's my question.
Council, any thoughts?
Mr. Chairman, so then we would essentially just move the language in subsection D up to subsection C and make it another Romanet up there.
Okay, so that's suit you, Ryan?
Yep.
Senator McDougall moves, Senator Stewart seconds that amendment. Any discussion? Hearing none, all in favor signify by saying aye. Aye. All opposed, that amendment's adopted. Bill's before us. It's been moved to report the bill as amended. Clerk will open the roll. All right.
Ayes 13, no 0.
Thank
All right.
you, Mr. Chairman.
8:33.
Yeah, keep those good thoughts coming. This is another one that, this one came about I happened to stumble into a meeting with the Senate Bill 833 in a discussion with a sheriff and a United States Marshal when it became evident that the use of exigency is prohibited in the code. However, in the cases of abduction of children under that section, the pen registry, the trap and trace, is not able to be used. And, what this bill does is try to address
Mr. Chairman,
several.
I just would like to know what those terms are.
Agency?
No, the,
Trap and trace?
yes, and pen registry.
Okay. People commonly think of whenever you ping a cell phone, you're triangulating the location in which the individual is. But it doesn't actually give you the exact location. So when they do the triangulation of where a cell phone had been used, you have a general area. You don't have the exact area. So an individual may have come through and it may triangulate in this area right here, well, that individual could be in any building or in the middle of the road or whatever. With the PIN registry, you get more of a real-time understanding of where they were using the phone. In other words, they could have been in the Domino's Pizza shop or called Domino's, and you know where they're going and what they're doing. So the trap and trace will allow them to be more specific on where they can find that individual. And this arose out of two situations in my area. And you know, in the conversation of how you better find these individuals, that conversation started with the law enforcement community that were actually trying to find these individuals. The one thing that really stood out to me was the National Center of Missing and Exploited Children in Tennessee Bureau of Investigations showed that 50% will be killed within the first hour of a true abduction. 75% will be killed within 3 hours once they're abducted. 88.5% will be killed within 24 hours. So that only leaves 1% of the children that are under a true abduction of surviving that abduction. And you know, the legislation that I'm bringing forward does not really change the invasion of privacy. It doesn't change the requirements of the agency under the law. It allows the release of, it doesn't allow the release of the content of the communication. All it does is in agency, when it's declared, it on the PIN registry, it's including the missing children's part. And also the fact that if a law enforcement's life is under and the public is under complete danger. So it all came about, and let me just give you two brief incidents that occurred. One in Washington County where the mother went in at gunpoint, took the foster kids that were in a foster home. One of the children was abused with a boat propeller and hospitalized. All this took place in the way that it's done now when the agency is declared they don't have the trap and trace ability in those situations. So it took several hours in order to find these children, and it took 6 hours total. They were found in Marion, Virginia, after being abducted in Washington County, Virginia, and they were recovered safely. However, it came from it didn't come from the ability to track them through this method. It came actually through interviews of family members who knew of a motel that this individual stayed, and they were able to find the two children and recover them. If that registry had been involved, they would have been able to track and find them because they had found that she had used that cell phone. The other one happened in Pulaski County. Curtis Duggar, he and others that were with him committed a violent crime of armed home invasion and sexually assaulted the individual at the home. They knew he was a flight risk. They knew he was in immediate danger, but they couldn't utilize this technology. And before they were able to get the warrants, get everything processed, he shot an officer in the head in Tennessee, and that's where they ultimately got into a gunfight with the individual and killed him. But, you know, had this been in place, they may have been able to track this individual and find him prior to the law enforcement officer getting shot and killed. After much conversations, and I have a lot of information on this. If y'all want a copy of it, I can give it to you. After much conversations, I just felt it was something that we need to look at and we need to do. In Virginia, I think we're only one of 15 states that doesn't allow it. And in order to protect some of these children that are going missing under true abductions, it's something that we need to look at.
All right. Anybody have any questions of the patron? Let me ask, and I don't know whether council can answer this or not, but when is disclosure of real-time location data prohibited by federal law?
I can't answer that, but I do know I had the marshal services that track these individuals in the room with me, and they felt like this would give them that authority to do it.
Is it prohibited, and I don't know whether it's prohibited by federal law without a warrant? State Police, I don't know whether you have an answer.
Well, Mr. Chairman, I can tell you that I have some background in criminal investigations on this point. It's not legally authoritative, but I'll take a stab at it. Federal law requires, under different circumstances, either a court order to get location data, just like any other electronic records under the, well, now I'm going to forget the name of the federal law, but they do require some legal process, either court order or search warrant, depending on the types of records you're going to get. So my interpretation of when required by federal law would be pursuant to a court order, and the exception there is for exigent circumstances. No court order is required to get those records where there is an exigency involving life or limb.
So I mean, does this change the definition of exigent circumstances? And I don't know whether Steve or Charles can answer that.
It would not change the definition of exigent circumstances.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth Attorneys. You may recall in 2012, the U.S. Supreme Court decided United States versus Jones dealing with GPS devices and the placing of GPS devices on certain properties such as cars. The basis behind that particular decision was of a trespassory nature. Justice Scalia came up with this concept of trespass on the property, and that was the justification and the real recognition as far as why you had to have a search warrant in order to place a GPS device. As a response to the U.S. Supreme Court's opinion in U.S. v. Jones, we, and I was involved with it, Mr. Benjamin was involved with it, we crafted the law that codified that, and we had to do it on a very quick basis. The following year, we realized that in coming up with a search warrant requirement for a GPS device, there was very little difference between a GPS device and the real-time location data on one's cell phone. And so we went further than what the U.S. Supreme Court required under U.S. v. Jones, and we went further than what the Electronic Communications Privacy Act required. The lieutenant from the state police is accurate as far as under ECPA, you have to have a court order in order for real-time location data, with the exception of the GPS. But the GPS is decided under the trespassory nature as opposed to ECPA. And so we went further as far as Virginia law, and we put that real-time location data requirement in 19.2-70.3. What Senator Carrico is trying to do here is taking those exigency circumstances definitions and requirements from 70.3 and also apply them to the trap and trace in 70.2, so that they are, whether law enforcement is using a 70.2 trap and trace or whether they're using the cell phone pinging in 70.3, the exigency circumstances as defined there would be the same.
So this conforms it?
This conforms it with 70.3.
Okay.
And in fact, that's where the language comes from, is 70.3.
Senator Stewart.
Mr. Chairman, actually, I've got a question for Mr. Benjamin. Understanding what Senator Carrico is trying to do, and I support what he's trying to do, Mr. Benjamin, do you think this is narrowly drawn enough so that we're not taking it too far, I guess is my question.
I can't voice any objection to it.
Thank you.
All right, Senator Peake.
Yes, Mr. Chairman.
He just became my favorite guy.
It's taken a long time.
It's taken a while. Yeah.
Mr. Chairman, and whether Senator Carrico or one of the other witnesses, how long does it take to get this trap and trace? What exactly is the trap and trace?
I'm going to let the lieutenant from the state police, because I've never went through that process. My understanding, it could take from 15 minutes to 3 hours. I'm not real sure.
All right.
And Mr. Chairman, do you call somebody do you just call somebody and they can give it to you? Thank you.
Mr. Chairman, Senator Peake. Yes, sir, Senator. if in the event of an exigency, the phone company can start providing that data within minutes upon notice of that exigency, our high-tech crimes division gets involved and can get the equipment to support that and get the real-time updates within an hour or so. Yes, sir.
All right. Anybody oppose this?
Move to report.
All right, it's been moved and seconded the bill be reported. All in favor, open the roll. He's got a cell phone.
Ayes 9, no 0, 1 abstention.
All right.
And the last bill, Mr. Chairman, if, and I don't,
886.
I don't know, the policy or committee may be not to take anything by. I'm not real sure. This came to me on Monday, and I dropped it on Friday. And it's kind of in a sense of, there's a bill working its way through the House that the psychologist who has testified in many of these cases just couldn't be here today, so I couldn't tell you what the bill actually gets to. So I don't know what you want to do with it.
Well,
I
it
can
may save you a little bit of time if we dispose of this today, and I'll tell you, and I don't want to be unfair with you, but this imposes a lot of new requirements or a lot of requirements that would seem to freeze the qualification of persons who are able to conduct these kinds of assessments. And at least on first glance, I mean, it seems to create a pretty significant barrier to entry for anybody new to qualify to conduct these assessments. And
the thing that I can tell you, the qualifications and the concerns were in the House bill, the qualifications are here and mine's here. I don't know if there's a middle ground. And it's one of the things that's come to my attention since the bill dropped is the cost to even be able to do it for local agencies. And that's what the concerning thing for me is. I think it's going to have a fiscal impact, and I don't know what that is right now.
Senator Stewart.
Mr. Chairman, Senator Carrico, I know your dedication to law enforcement, and this must be very important to you if you put it in. I just wonder, is this something you want to carry over for the year and continue to work on it?
The thing that I can't articulate. I know what the bill does. I can't articulate the cost of that, though. I think it's going to have a significant cost, and I mean, if you want to take action on it now before I have that, then all I know could be done is you send it to finance, because I think there's going to be a cost to that unless you want to take it by until I can find that out.
Well, I guess there's an option of carrying over for the year too, if you want to continue to work on it.
Sure.
But where? I mean, I guess if you want to take it to finance.
It was a last minute bill that I dropped just to address a concern, and if a year will give me plenty of time to work out. So.
Does that suit you?
Yeah.
All right. I'll second that.
It's not as big a change as it seemed. All right, there's been a motion properly seconded to carry the bill over for the year. Open the roll. All right.
13, no 0.
Before you go away, Senate Bill 833 that reported, Senator Stewart moves, Senator Howell seconds the motion to reconsider the vote by which that reported. I think there were some votes that were inadvertently not cast on that. All in favor of reconsidering that vote signify by saying aye. Aye. All opposed. Bill is before us. Senator Stewart moves. Senator Reeves seconds. Motion to report that bill. Clerk will open the roll.
Ayes 11, no 0, abstentions 2.
Okay. Senate Bill 70 from Senator Favola. She's asked that bill be stricken. Senator Stewart moves. Senator Howell seconds. Motion to strike. All in favor signify by saying aye. That bill is stricken. With that, we've got bills by members of the committee. Huh? Okay, Senator McDougal says he's got two quick ones. Senate Bill 402, you want to do that or carry that over for the week? Okay, well, it's up to you. You can do it right here.
Let's do 398 first.
All right.
Mr. Chairman, Senate Bill
398.
398 deals with the penalty for DUI fourth. This would need to go to finance because it would increase the penalty. Right now, the penalty for if you are convicted of DUI third is the same as if you were convicted of a DUI fourth offense. So this would take it up to a class 4 felony, which is 2 to 10 years instead of 1 to 5 years. The person would already be a convicted felon. Somebody emailed our office saying we didn't want to create more convicted felons. You would already have to be a convicted felon because there was a DUI third.
All right. Anybody wish to speak in favor of this bill? In opposition to the bill? Bill's before us.
Move to report and re-refer to finance.
All right. Been moved and seconded to report and re-refer this bill to finance. Clerk will open the roll.
Ayes 13, no zero.
All right. Next, we've got Senate Bill. What do you want to do next?
408.
408?
Mr. Chairman, Senate Bill 408 this came to me through, just like the other, through one of my local prosecutors. Right now, under the current code, we say that certain extracts, if they're in a liquid form, are illegal. If they're in a solid form, then we classify them as misdemeanors. So what's occurring is that there's a lot of waxy or solid cannabis derivatives that are more potent in their waxy or solid form, but because they are in that solid form, they're the unclassified misdemeanor. So this would take them, if they're above that 12% concentration, to be a felony. And apparently, this is one of a big problem that's going on in the distribution arena today. Mr. Chairman, the negative about this is the fiscal impact that I received through this process was more significant than I anticipated, so it would also need to go to finance, but it means it's a bigger problem than I also anticipated as well.
So it just treats the same drug the same way with different forms?
Correct.
All right. Is there a motion to report and re-refer to finance or some other motion?
So moved.
It's been moved. So it has a big fiscal impact.
Big.
Motion has been made, properly seconded, to report and re-refer to the Committee on Finance. Clerk will open the roll. All right. Next bill.
Ayes 14, no zero.
Mr. Chairman, then the other one I had is Senate Bill 402. This is not dissimilar to the one that Senator Servell talked about earlier, but we take a different approach in it. It says there's a substitute that Charles worked on over the weekend.
Senator McDougal moves, Senator Stewart seconds the adoption of the substitute. All in favor signify by saying aye. All opposed, substitute's adopted.
Mr. Chairman, what we've done with this legislation is we found that that right now, if you're charged with a DUI and convicted, you're required to have ignition interlock on your vehicle in order to get a restricted license. And then this committee is always, and you reported it and sent to finance and went to finance. You're required to have ignition interlock on your vehicle in order to have a restricted license. The restrictions, as this committee knows, have become more numerous across the years, and it is very difficult to police or enforce those restrictions. What this bill would do is set under that first offense, DUI, not second or third, if you would have to have ignition interlock on the vehicle to operate it, but you would not have to have any restrictions on the locations where you could drive as long as you had a secure transdermal alcohol monitoring device, which we call a SCRAM bracelet. In most jurisdictions, it's certainly in Metro Richmond, are using those now in addition to the ignition interlock. Mr. Chairman, I know that some, I think a person waiting patiently near the podium is going to say that there's some other devices that could be used. Scram is the only device that I am aware of that's being used by courts now to deal with this. That's why I picked it. It doesn't really matter to me what the device is that's measuring the alcohol, but this would ensure that if you got a license allowing you to drive anywhere, like go to the grocery store or job interviews, that that we were ensuring that you weren't consuming alcohol during that time of the restriction.
So as this works its way through the process, are you open to amendments that would open it up to similar devices?
Absolutely. I'm not trying to restrict the technology.
And
It's
if
the only
somebody's got
technology
language today, we can do that, but anybody have any questions of the patron?
Yes.
Senator Peak.
Mr. Chairman, does this mean that they are alcohol-free for the entire 12 months, 24 hours a day?
Mr. Chairman, yes, the way the Scram bracelet works, secure alcohol device, is it measures your alcohol content and reports that every 24 hours. It links through a telecommunications system. That report comes back. So the court would revoke your restricted license if you consume alcohol during that time. The ignition interlock device prevents you from operating a vehicle if you've had, in essence, it'll shut down over a .04 level, but it doesn't do anything to prohibit you from illegally driving another vehicle that you don't have ignition interlock on.
But
this would allow, you still have to have that interlock, but let the court know if you were consuming alcohol at all.
But this, gives you an option. It doesn't require
Correct.
you to use the Scram, and I'm concerned about the cost. I mean, we've got some, folks who are, paying like $6 a day for the ankle bracelets, and it's breaking them. And I just am concerned about that. So my understanding is this gives them an option.
Mr. Chairman, that is correct. And so one of the things that we've found, and there's no way to get around it, you have to have ignition interlock on your vehicle. This gives the court another option. The court can decide not to allow somebody to have this, but gives them the option to expand their driving if the individual want to request it.
Is it the court's option or the individual's option? I mean, can
Mr.
you
Chairman-
make that
Mr. Chairman,
choice, or does the court
Mr.
have
Chair-
the ability to impose this?
Mr. Chairman, today, a restricted license is optional by the court. Almost every jurisdiction grants them, but you're not required to be issued a restricted license. This also says the court may upon request. So it doesn't change the optional nature of.
So the DUI defendant has to request it.
Mr. Chairman, that is correct, but that's the current law today for a restricted license. So we didn't try to change that. We tried to add one additional option in the same light of what we have today.
All right.
Mr. Chairman.
Sir Pete.
One follow, Senator McDougal. Is this, if the defendant wants to do the ignition interlock, he can then drink as long as he does not try to drive. If he wants to have a restricted license, but if he wants a completely unrestricted license, he then undergoes this extra step of having zero alcohol for 12 months.
Mr. Chairman, if one enrolls in the VASAP program and successfully completes it, then one of the conditions of VASAP is that you be alcohol-free. So even under the ignition interlock, you cannot drink and successfully complete VASAP. One could choose not to have a license at all, not to get a restricted license for the year, but you're never going to have a license without successfully completing VASAP. So I don't know that the example the senator uses is quite accurate, but what this does do is says, if you are willing to be continually tested for alcohol, then we're going to eliminate those restrictions on where you can drive. So you would have more driving freedom, knowing that the public is more protected because you're not consuming alcohol.
And so, Mr. Chairman, they could still just have the ignition interlock and have a restricted license.
Yes, Mr. Chairman, it does not eliminate the court's option for that.
All right. Anybody wish to speak in favor of this?
Mr. Chairman, members of the committee, Chris Legault for the Coalition of Ignition Interlock Manufacturers again. We're in favor of the policy behind this. The language is still troubling a little bit to us because it does eliminate some alternative choices. And I'll be happy to work with the senator to come up with some appropriate amendments on that. It's my understanding that the SCRAM device that this is really very specifically drawn to is used and is marketed by the manufacturer of that device for second and subsequent offenders, perhaps to the exclusion of first offenders. It's also my understanding that there are alternative devices that cost about a third less. The SCRAM device costs about $13 to $15 per day, and the alternatives are $4 to $5 per day. I am getting a list of jurisdictions that are, using the alternative devices at present in Virginia and elsewhere. They are used in the state. I have confirmed that much, and I'll get you the list that you requested. But I haven't read through the substitute, obviously, but the language that talks about secure transdermal and wearing the device. Some of these other devices aren't worn and they're not secure transdermal. They operate on a different technology. And as the senator indicated, we don't want to exclude any technologies. We want to expand the number of technologies and the choices that offenders can make if they choose to have an alcohol sensor in play as well. The SCRAM devices, as I understand it, that's the person who really recognizes that they have a problem and they really desperately want to quit. They want to go hardcore and be monitored all the time for that in order to stop their drinking and or driving at the same time. So,
thank you, Chris.
Appreciate it. Thank you.
All right, next. In support?
Yes. Maria Jankowski, Virginia Indigent Defense Commission. I don't have any objection to this bill. In fact, I would suggest that it might be better than Senator Sorvel's bill because as I read the two, this gives the indigent person a choice. We're very, very, very concerned with price. And you don't have to take this option. You can just drive to work and drive to church and sit at home every night. If my reading of Senator Sorvel's bill is correct, not only would it take the choice away from the indigent defendant, but it would have them stuck having to pay for ignition interlock for potentially 12 months, which is concerning. So
right.
I would ask you to consider cost.
All right, thank you. Anybody else in support of this bill? Yes, no? Anybody in opposition?
I was going to follow Mr. Legault's comments. My name is Kurt Erickson. I'm with the Virginia-based Washington Regional Alcohol Program, which is an anti-drunk driving organization. I'm also here for Mothers Against Drunk Driving. Just wanted to echo Mr. Legault's comments. And I guess the concern that we have is the coexistence between the ignition interlock program, the existing ignition interlock program that this legislative body enacted in 2012, and any type of transdermal device. If just for the fact that we're still a Commonwealth that annually convicts over 20,000 persons, still to this day, for drunk driving, we just want to make sure we don't displace the efficacy of the interlock program.
All right.
Mr. Chairman, and I think we were concerned the way Charles did a really good job working with us. We were concerned the way the first draft was written, that it was not as clear. This is our 100% agree that we don't want to do anything to harm the ignition interlock because that prevents people from starting a vehicle, operating a convicted vehicle after their alcohol. This is an addition to, not in lieu of. So I want to make that very clear because I think that that is a valid point that we all need to be concerned about. We want to make sure people are not driving after consuming alcohol.
All right, let's hear from the Commonwealth attorneys.
Mr. Chairman, Matthew Kite, Commonwealth Attorney for King William County, speaking for the Virginia Association of Commonwealth Attorneys. Our primary concern and opposition for this bill, however, is in lines, looks like 287 through 292. And as we read that, and I just heard what Senator McDougall said, as we read that someone can obtain a restricted operator's license simply by having the transdermal device, not a ignition interlock. And of course, the concern is that with the ignition interlock, it keeps the car from starting. So they could have this device, have a restricted operator's license, according to how we read that part of the statute, and drive off.
Doesn't it say and?
It says, however, and is ordered to wear a that is not equipped with a functioning certified interlock device and is ordered to wear, and has it on a different car. So they're still able to drive a vehicle without without ignition interlock.
Can drive a different vehicle.
Yes.
I see. Can you, that's a good catch. Can you, quick fix for that?
Well, Mr. Chairman, I think that's being misinterpreted because what 287 and 288 say is any person who is prohibited from operating a motor vehicle that is not equipped with the interlock, meaning that any person who has a DUI conviction cannot receive this license unless the conditions in A and B are met. So I'm unclear where that interpretation is coming from.
Yeah, the functioning certified. I'm sorry, where are you? Which part?
And looking at 287 and
Yes.
288, the introductory clause is any person who is prohibited from operating a motor vehicle that is not equipped with an interlock system
Yes.
cannot obtain the permit unless the conditions in A and B are met.
I think Charles is right about that. Steve?
No, I agree. The predicate is that they have been ordered not to operate any motor vehicle, period, unless it has an interlock. And so, sure, although they can go borrow somebody's car and operate it, they would be in violation. They're prohibited from doing that.
So I guess my question would be, you have a different section of the code that, or the amendment, that 244 through 246, which allows them to have it as a condition of a restricted operator's license. That would seem to accomplish that goal. The however's language in 287 going forward appears to let them.
All right, Senator Stewart.
Mr. Chairman, I think all of us, well, most of us support the concept here, and we are sensitive to Matt's concerns, but I trust Senator McDougal will work through this and make sure it's in the proper order, but.
You're going to get together with Commonwealth attorneys, make sure they're happy with that language? Okay.
Because of the hour, I'm going to move the bill be reported.
All right. And does it have to go to finance?
I don't think so.
Does or does not?
Has an impact on the people who purchase it, but not the Commonwealth.
You want to go to your subcommittee?
I'll-
Let's
I'll-
report and re-refer the Committee on Finance.
I'll amend my motion to re-refer.
All right. All right. Motion to report and re-refer is before us. Clerk will open the roll.
Ayes 14, no zero.
All right, we're about out of time. Kristen, can you handle Senate Bill 51 real quick?
Yes,
I think
Mr.
that's
Chairman.
a quick one.
This bill-
Senator Edwards is out sick.
This bill is a recommendation of the Code Commission. It repeals section 60.2-114.1, which required employers to request new employees to disclose whether they have an income, a spousal support or child support income withholding order. That code section has since been superseded by the language that we put into 63.2 with the DCSE language requiring employers to report new hires to the Virginia New Hire Reporting Center.
Anybody wish to speak in favor or in opposition to this bill? Family Law Coalition supports it. Senator Stewart moves. Senator McDougal seconds. Report this bill. Clerk will open the roll. And that's it. I know Stanley's gone. Okay. I was going to do one of his bills. Well, Family Law Coalition is here today. And 178 and is not going to be here in full force on Wednesday, I believe.
No, Mr. Chairman, I hadn't planned on having anybody here on Wednesday. I can try to make arrangements since Senator Stanley's not here.
I don't know where Bill is.
There's also corresponding bills on the House side that we're going to address this afternoon, so that's where we are.
Were there any other bills that you all were
No, sir.
here for? Yeah, I was trying to get this one.
I appreciate that.
They do not like this, right?
We do not like this, and the Commission on the Needs of Youth do not like it either. And there was a report that I think Ms. Walsh had about this.
Toby, you putting out APB on Senator Stanley? Well, while we wait for Senator Stanley, anybody else on the committee have a bill we can do quickly? All right, Senator Chafin, 381.
Mr. Chairman, this bill, 381, right now it's illegal to pass a stop school bus, and anyone who does so is guilty of Class 1 misdemeanor. I was asked to carry this bill, and this bill would make reckless driving a felony, a Class 5 felony, in the event that the passing of the stop school bus resulted in a serious bodily injury to someone.
Yeah, and I mean, Steve, let me ask you, I mean, does this have the potential to make essentially negligence a felony? I mean, accidentally being distracted.
Yes. Yes, it does, Mr. Chairman.
I mean, are there other circumstances in which we, and I ask this out of ignorance, I mean, in which we make simple negligence a felony? I know that aggravating circumstances are, I mean, certainly a DUI death is, but how about simple negligence?
No, we do not.
Ben, is that your intention?
Mr. Chairman, this bill is somewhat similar to this committee considered a few years ago a bill to make a felony out of reckless driving when it resulted in the death of a state trooper. And there are other classes. I believe there have been other requests to make the result, when the result was bad of the reckless driving, to make it a felony. I was requested to carry this bill by one of my school systems that has had a continuing issue with people failing to stop for school buses and passing those buses.
But I guess reckless driving isn't simple negligence. I mean, that's an aggravated form of negligence, isn't it? So is causing a serious bodily injury, passing a school bus when engaged in reckless driving, is that already a felony, or is that some middle ground we could consider adopting?
I don't know the answer to that, Mr. Chairman. I do not think it is currently a felony, and I would I would concede that it is negligence. It might be gross negligence to be passing I don't think it's simple negligence to knowingly pass a school bus, but you might have a situation where it could be simple negligence, a distracted driver. I know that was the situation with the bill that contemplated this law with regard to a state trooper. There was a distracted driver that resulted in the death of the officer.
All right. In any event, this would need to go to finance. Anybody wish to speak in favor of or in opposition to this bill? Bill's before us.
Mr. Chairman, not to belabor it, but with all these, if you injured yourself and that was the physical danger, then you could be charged. So if you pass the bus, swerve to avoid hitting the child, run into a tree, hurt yourself, you could be guilty of a felony if you didn't hurt anybody else. Because it doesn't limit the physical injury to someone else.
Kristen?
Yep, that's correct, Mr. Chairman. It says to another person.
I'm sorry? To another?
Yes.
All right, there had been some suggestion that we put in a definition of serious bodily injury.
Yes.
All right, Steve?
I think what we were going to do was suggest that it be cause serious bodily injury as defined in 18.2-369.
All right, is there a motion to that effect? It's been moved and seconded. All in favor of adopting that amendment, signify by saying aye. Aye. All opposed?
And that would be.
All right, bill's before us.
Report and refer to Senate Finance.
All right, it's been moved. Is there a second? Senator Chafin, you want to second that?
I'll second that.
All right, it's been moved and seconded. Report and re-refer to the Committee on Finance. Clerk will open the roll. All right.
Ayes 11, noes 3.
All right, Senator Stanley, last bill, 178. And
Mr. Chairman, I think there were some amendments were adopted. I think as far as we're concerned. Yeah, in rehab.
so we don't need to re-adopt them.
No, just, there's a lot of language.
All right.
So, Mr. Chairman, what this does is basically it gives parents the power of attorney to delegate custodial powers without having to submit to social services their children into the social services or court process. We do have unlimited circumstances, abilities of parents to, by power of attorneys, to do that. What we're trying to do, and this has been called Safe Families for Children. This has been a pilot program in the Commonwealth of Virginia. Many of us, if not all of us, voted for the budget amendment that provided for that. Worldwide, in 15 years, it's provided for 40,000 hostings, 92 reunifications, and it's found in 41 states and worldwide. Virginia's pilot program's gotten 42 hostings, many on the edge of care. We've had 100% reunification with the family and kept them from being diverted to foster care. This basically gives parents a choice for the caregiver of their caregiver in a crisis. It protects children without from abuse potential. What we're trying to do is also drive forward in the same way the social services, which is reunification ultimately with the family. But what we have is a service orientation where the parents or the caregivers, non-parental caregivers, would be vetted through a certain agency or program or private agency, and that this would enable parents to actually do something and empower themselves to avoid what may be coming and to help the children without the problem of foster care. And so that's the bill, Mr. Chairman.
All right, anybody wish to speak in favor of the bill? Step right up.
Chairman, members of committee, my name is Patrick Neff. I'm with Patrick Henry Family Services, and I'm the director of Safe Families, and we had the pleasure of being the implementer for the pilot program for the last 18 months. And over those 16 months that we were and are still keeping records, we had over 42 hostings, many of them, as the senator said, on the edge of care. We feel that the program was a great success. We have, as it was stated, there are over 41 states that are currently doing Safe Families. In the last 2.5 years, we've been able to help 15 other states adopt legislation just like this for Safe Families. It's extremely important for families to be able to feel comfortable about being able to go to folks in their community and get a power of attorney to be able to utilize these relationships in a non-threatening way. I have testimonies. We had the privilege of working with Amherst County, Lynchburg, and the 4 surrounding county. I have recommendations here from the director of Amherst County where we were able to do 5 of those hostings. That director highly recommends Safe Families. And also I have recommendations from the CPS workers throughout the region that we were working with that highly recommend Safe Families. Also, I have a recommendation from the Director of Social Services of Roanoke, which are very anxious for us to be able to move into their area. We feel like the pilot program was very successful. 42 of those children, those families, were diverted from foster care. It's hard to put a number, but we feel like we've saved literally in this pilot program by diverting those children away from foster care millions of dollars. This is a prevention program that really works with DSS to get ahead of the problem. And one of the reasons we liked the, and let me just say this, many of the other states have adopted a power of attorney as well. It works very well. Matter of fact, the commission, one of the things we were to look at was to see if the power of attorney would work well for us, and it has. There's been no abuses. And so we are giving our recommendation. Would like you to adopt this.
All right, thank you very much. Family Law Coalition.
Thank you, Mr. Chairman. As I indicated earlier, Mr. Garriott was here on behalf of the Commission on the Needs of Children and wanted to relay to you all that they object to this as well. I was there when the initial pilot program was approved in 2016, and we expressed our concerns, but certainly it was put in place. And I note that the pilot program had a 90-day provision with an extension for 90 days, and this now goes to up to a year. There's no criteria for establishing that you are a 501c3 that assists parents and legal guardians in the process of delegating parental and legal custodial powers over their children. So we have concerns about who might be establishing themselves as a 501c3. With regard to the delegation on behalf of service members, there's already the Military Parents Equal Protection Act that allows for court intervention if someone's going on deployment to be able to delegate their custodial or visitation rights to another person under court supervision. So we believe that it's a little soon to expand this over the entire Commonwealth and to allow for delegation of up to a year or more than a year for service members. So while we appreciate Senator Stanley's advocacy on behalf of the Safe Families, if you look at the report, the Department of Social Services is recommending further study rather than going statewide at this time, and we support that.
Anybody else wish to speak in opposition to this? You know, and let me ask you, I mean, we've got the kinship foster care. I mean, does that largely achieve in a more regulated way many of the same purposes?
I think it does, Mr. Chair.
Right. And this basically allows somebody to direct their child to be given it up to somebody for up to a year.
Correct.
Pursuant to power of attorney.
Correct. And if you look also, it provides that either person or the agency can revoke that power of attorney, but it doesn't say what happens if that happens. So if you have two separated parents and one revokes and one doesn't, what happens to the child? Does the child go back to the custodial parent who may not want them? Do they go to the visitation parent? So there's a number of problems in our view.
All right. Any questions? Bill is before us. Finish their study. Finish the pilot project.
Moving forward.
Oh. Senator Stewart.
Mr. Chairman, substitute motion that the bill be carried by for the year and allow them to finish their study.
All right, is there a second? A letter? I'll gladly write a letter.
From the chairman?
Sure. All right, with a letter to whom?
My mom?
I got a few things to say to her. Let's, a letter to the Department of Social Services. Okay. Senator Sasslaw.
If this bill would have been in effect in the late 40s, early 50s, my mother would drop me off and never come back.
All right. The substitute motion before us is to carry the bill over for the year with a letter from the chair to the Department of Social Services. Clerk will open the roll. All right. Bill's carried over for the year. Thank you very much. Committee will rise.